The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Seen it? Mr. Rosenberg.
May it please the court, I would like to introduce a third-year qualified law student, Sean Hodgman, who will be presenting argument for Mr. Derek Fallon. Mr. Hodgman is a student at the West Virginia University College of Law and a member of our Supreme Court litigation clinic. Thank you.
Welcome, Mr. Hodgman. You may proceed.
May it please the court. Failure to grant Mr. Fallon's requested relief undermines the categorical approach and the constitutional principles stated in United States versus Davis and the principles of the United States Sentencing Guidelines, leaving Mr. Fallon to be a victim of a complete miscarriage of justice. There are two topics I'd like to talk about. First, Mr. Fallon is entitled to Section 2255 relief, and second, Mr. Fallon is not a career offender under the United States Sentencing Guidelines. Mr. Fallon challenges under Section 2255 because his sentence contains a fundamental defect which results in a complete miscarriage of justice. This fundamental defect was the district court's failure to properly apply the categorical approach in determining whether or not Mr. Fallon was a career offender. Although this court's prior precedent in Foote states that a mere challenge to the wrongful classification as a career offender does not constitute a fundamental defect, this has been superseded by United States versus Davis Supreme Court case. Specifically,
did Davis involve the sentencing guidelines?
No, Your Honor, it involves 18 USC Section 924C. The language at issue was the identical language between the two.
But isn't there authority that the sentencing guidelines are not controlled in the same way as the statute?
United States versus Beckles tells us that a vagueness challenge is precluded, but this does not make the United States sentencing guidelines completely immune from constitutional scrutiny. And United States versus Davis tells us that two constitutional principles are implicated: procedural due process and separation of powers. And this leads to an issue of a constitutional dimension.
So following up, so explain to us what due process challenge, other than vagueness, that Davis creates that is applicable to the career offender designation under the guidelines?
Specifically, United States versus Davis puts a finer point on a pre-existing rule of criminal procedural due process. And this procedure was laid out in United States versus Taylor, which is the categorical approach. United States versus Davis continues to put a finer point and rehash this categorical approach. And if the categorical approach had been correctly applied by the district court, Mr. Fallon would have not been wrongly classified as a career offender. Due process itself is implicated by the fact, as we know from United States versus Davis, that the failure to use the categorical approach would lead to a lone judge interpreting what a crime of violence is different from the next court and the next court. And this implicates the right of an ordinary person to have fair notice of the laws that they'll be sentenced under.
But I had read Beckles as telling us that in the views of the Supreme Court, the sentencing guidelines with exactly the same language as a federal statute are to be treated different.
United States versus Beckles certainly tells us that the sentencing guidelines are different than statutes and should be treated differently, but it's limited specifically only to vagueness challenges. And Mr. Fallon does not bring a vagueness challenge, he brings a procedural due process challenge.
So regarding Davis, tell me what it is, do you read that the court says to reject it ordinary case categorical approach to any of the analysis of the residual clause?
United States versus Davis outright rejects the ordinary case categorical approach and accepts only the categorical approach where you weigh the elements of the targeted offense against the general conspiracy offense. So in United States versus Davis, you have the Supreme Court dealing with three different approaches. You have the case-specific approach, the ordinary case categorical approach, and the categorical approach itself. The ordinary case categorical approach and the case-specific were found to not meet the constitutional demands, specifically because it would require a judge to conjure up what they believe an ordinary case would be, and that implicates the same issues of fair notice and separation of powers. Separation of powers is implicated because this definition, this crime of violence definition, is repeated 12 times throughout United States Code and the sentencing guidelines. It has a very particular meaning set out by Congress. And separation of powers is implicated because having a judge arrive at a certain definition for a separation of powers in one statute, and then it means a different thing in another statute, despite the identical language, would go contrary to Congress's intention. Congress's intention is even more on point given its 2008 bipartisan First Step Act that shows a decades-long change away from retribution and towards rehabilitation. I'd like to now talk about the fundamental defect and specifically the miscarriage of justice for Mr. Fallon.
Before you do, tell me what, as a crime of violence, if we use the ordinary case category approach, would this 2012 conspiracy charge conviction constitute a crime of violence?
Respectfully, Your Honor, this court's precedent in McCollum tells us that we use the regular categorical approach rather than the ordinary case categorical approach.
But answer my question. If we did use it, would it qualify?
No, Your Honor, it would not. I'd like to talk about the implications of the miscarriage of justice. Mr. Fallon was classified as a career offender, which increased his advisory range by nearly 70 months, an increase of nearly 25%. And even though Mr. Fallon was ultimately sentenced under his advisory range, the Supreme Court tells us in Molina Martinez versus United States that if the advisory range is incorrectly arrived at, the ultimate sentence, even if it falls outside of the advisory range and under the advisory range, the error itself will be sufficient to show a reasonable probability of a different outcome. And that brings me to my next point. Mr. Fallon is not a career offender under the United States sentencing guidelines. Specifically, the issue is Mr. Fallon's third offense, a 1959A conspiracy to commit murder in aid of racketeering. At the time, a crime of violence was defined in three different ways. There was a force clause, an enumerated clause, and a residual clause. The categorical approach and the question really is, where does crime of violence, where does the 1959A fall within the definition of crime of violence under those clauses? This court has already answered that question in United States versus McCollum, where it says that a 1959A offense, if you apply the categorical approach, is not a crime of violence, because if you look at the elements of a 1959A offense and you compare them to general conspiracy, 1959A criminalizes a broader range of conduct. And specifically a broader range of conduct because 1959A does not require an overt act. Because 1959A criminalizes a broader range of conduct, it categorically cannot be a crime of violence. And this court later extended that same holding to include all RICO conspiracy offenses. Had the district court applied the categorical approach as it was supposed to, Mr. Fallon would have never been deemed a career offender. Just because the language of what constitutes a crime of violence has since changed and since been amended to exclude the residual clause does not render McCollum an opposite. McCollum is clear. The categorical approach applies to 1959A offenses, and because it applies, it is categorically not a crime of violence. I'd like to go back to talk a little bit about why specifically United States versus Davis supersedes this court's precedent in Foote. First, Foote, if read broadly, would stand in direct conflict with United States versus Davis, telling us that the failure to use the categorical approach implicates an issue of a constitutional dimension. Second, implicit in Foote's holding is a 1974 case, Davis versus United States. Easy enough to confuse with 2019 United States versus Davis. But in the 1974 case, Mr. Davis challenges his conviction because the statutory language he was convicted under had since been reinterpreted. At the Supreme Court, the government argues that this is a purely statutory issue, and Section 2255 relief is implicated only when there is an issue of a constitutional dimension. This is the test the government argues for, and the Supreme Court says that test is too onerous. It's too preclusive of Section 2255 relief, and that is how we get the fundamental defect test.
So where we are with this is a question of what does Davis do? Davis, at least from my perspective, seems to be dealing with vagueness. But do you contend, as it seems to appear in your brief, that we should apply the categorical approach used to the enumerated approach or the force clause to the residual clause?
Yes, Your Honor. We argue that the categorical approach should be applied to the residual clause, and that's what United States versus Davis tells us. United States versus Davis had two parts to it. It had this discussion on constitutional dimension, this discussion on procedural due process, these different approaches that district courts should use when interpreting crime of violence, and then it moved into the definitional discussion about vagueness. There's two parts to it, and we're bringing a challenge under the procedural due process aspect of United States versus Davis.
So you seem to be operating under the assumption that the residual clause is invalid. Is that really established in Davis?
We are not operating under the assumption that the residual clause is invalid. If the residual clause at the time existed and had been applied under the categorical approach, Mr. Fallon would not have been classified as a career. That the holding today is not going to rewrite Section 2255 law. It's not going to open the floodgates of litigation. It's going to be limited to a very narrow subset of facts, specifically where you're going to have someone classified as a career offender with the crime of violence definition, with the now non-existent residual approach, where the district court failed to apply the categorical approach correctly. As I said, the residual clause has been amended out of the United States sentencing guidelines, and this court's precedent tells us that 1959A is categorically not a crime of violence. These incidences simply are not going to occur moving forward. I'd like to briefly summarize. Davis qualifies this court's holding in Foote and states that the failure to apply the categorical approach constitutes a fundamental defect, which entitles Mr. Fallon to Section 2255 relief. This error that existed, this fundamental defect that existed, has resulted in a complete miscarriage of justice by Mr. Fallon serving an elongated sentence. Failure to grant Mr. Fallon's requested relief undermines the categorical approach as announced in U.S. versus Davis and the purpose of the United States sentencing guidelines. I'd like to reserve the rest of my time for rebuttal.
Thank you, Mr. Hogman. Mr. Sui.
Thank you, Your Honors, and may it please the court. I'm going to remove my mask. The district court correctly determined that the appellant was not entitled to vacatur of his sentence pursuant to United States versus Davis. The appellant asserts that his argument is not a vagueness challenge to the advisory guidelines, and in the same breath premises the claim on the Supreme Court's holding in Davis, which relied exclusively on the vagueness principles articulated in Johnson to invalidate 924C's residual clause. In Davis, the Supreme Court held that 924C's residual clause presented an inherent miscarriage of justice because its interpretation was dependent on a judge's estimation of the degree of risk posed by a crime's imagined ordinary case. The only way the appellant succeeds here is if a vagueness challenge, like the one first articulated in Johnson and repeated in Davis, applies to the advisory guidelines. Short of the residual clause of 4B 1.2a being void for vagueness, the appellant is left with no basis for relief from his career offender sentence. Understanding this, the district court correctly ruled that his claim was foreclosed by Beckles. Now, in Beckles, the Supreme Court held that the due process considerations first promulgated in Johnson and those which guided the Supreme Court to its holding in Davis are inopposite in the guidelines context. And for background, Johnson held that the residual clause of the definition of violent felony in the Armed Career Criminal Act was unconstitutionally vague because it left unclear both how to measure the risk posed by a particular crime and how much risk it takes for any crime to qualify as a violent felony. The court, as a result, invalidated the residual clause of the ACCA because it established enhanced penalties arbitrarily and without fair notice to defendants. But by contrast, the Supreme Court later clarified in Beckles that Johnson's holding did not apply to the career offender advisory guidelines because unlike the ACCA, the advisory guidelines do not fix the permissible range of sentences, but rather merely guide the exercise of the court's discretion in choosing the appropriate sentence. And when the Supreme Court held in Davis that the residual clause of Section 924C was void, it came to its conclusion entirely based on the vagueness grounds initially set forth in Johnson.
What about this court's holding in McCullen and Simmons insofar as the conspiracy convictions?
I'm sorry.
Why would McCullen and Simmons not, at least from this court's perspective, not indicate that the conspiracy convictions here constitute crimes of violence?
Yes, so the appellant's argument that he is entitled to relief based on McCullum and Simmons is flawed in the same way because those decisions followed from either the invalidation of or the subsequent removal of a residual clause. For example, the Simmons case was decided in 2021, and in that case, this court considered whether an aggravated federal RICO conspiracy offense qualified as a crime of violence under 924C's force clause. But that consideration only became necessary in light of Davis's invalidation of 924C's residual clause. And likewise, in McCullum, this court considered whether the federal offense of conspiracy to commit murder in aid of racketeering qualified as an enumerated crime of violence under the current amended version of the career offender guidelines, which contains no residual clause. The posture of the appellant's case is entirely different. He was sentenced pursuant to the 2012 pre-amendment version of Section 4B 1.2, which contained a residual clause. And as required by Beckles, he cannot challenge that residual clause on constitutional vagueness grounds. This is precisely why the district court, in this case, determined that Beckles controls here. Because all of the appellant's arguments, whether under Davis or McCullum or Simmons, at their core, they depend on the residual clause of 4B 1.2a being void in the first instance. In other words, if Davis does not have the effect of invalidating the career offender residual clause in the first instance, which it clearly does not under the Supreme Court ruling in Beckles, all of the appellant's subclaims involving McCullum and Simmons as well, and the categorical analysis, they must all fail. Now, in disputing the district court's conclusion that Beckles controls, the appellant argues on appeal that Davis's holding applies to all residual clauses, but that is not consistent with Beckles, nor does it comport with the Davis decision itself. First, the Supreme Court already ruled in Beckles that the residual clause of 4B 1.2 was immune to the type of due process vagueness claims articulated in Johnson. And that, by extension, applies to Davis, because the advisory guidelines do not fix the permissible range of sentences. Second, Davis dealt with the residual clause of 924C exclusively. Section 924C is punishable by a mandatory consecutive sentence and thus fixes the permissible range of sentences, unlike the guidelines, which do not. Thus, Davis is entirely consistent with the distinguishing line that was previously drawn between statutory and advisory guideline sentences in Beckles. Now,
Your colleague on the other side seems to suggest that somehow, which is really, I hadn't gleaned this from the briefs, but I guess this is his argument, that somehow the use of the categorical approach must give him victory here. I had thought the best argument was that he would rely on distinguishing foot, but maybe not. Maybe you can talk to both of those issues.
yes, thank you, Your Honor. So for there to have been a procedural or substantive error at the initial sentencing in this case, the residual clause of 4B 1.2 would have to have been deemed invalid at some point in time, and that has not happened here. And in the absence of a case finding that the residual clause provision of section 4B 1.2a is void, there is no error. More than that, we have the Supreme Court case of Beckles, and that explicitly says the opposite, that the residual clause of 4B 1.2a is not void for vagueness. And so the
appellants think that there is something else to be gleaned besides vagueness, that there's some other ground. You didn't hear that in his argument?
I did hear that, Your Honor. And I think I would respond to that by saying that it's an incorrect premise to rely on the fact that to rely on the notion that the sentencing court was required to apply the categorical approach. There was no such requirement here because the appellant does not fall in the category of defendants entitled to Davis relief in the first instance. And because he's not entitled to Davis relief, it follows that his crime of violence designation does not depend exclusively on the elements clause, the force clause. And that's because the residual clause was properly enforced at the initial sentencing. The district court was not tethered solely to the categorical approach at the sentencing in 2012.
But there was a residual clause in the sentencing guidelines.
Precisely, Your Honor, yes. And this again highlights the fatal flaw in the appellant's overall premise. All of his arguments are dependent on the residual clause of 4B 1.2a being void in the first instance, which Beckles already said is wrong. And even aside from Beckles, there are a number of post-Johnson decisions that contradict the appellant's claims. For example, in United States versus Mack, this court explained that following Beckles, the residual clause of the career offender guidelines remains in force, and we must now apply section 4B 1.2a with all of its relevant language, including the residual clause. In United States versus Brown, which was a case involving whether the mandatory guidelines were subject to vagueness attacks, this court held that the Supreme Court has yet to recognize a broad right invalidating all residual clauses as void for vagueness simply because they exhibit wording similar to the ACCA's residual clause. And in United States versus Rump, this court further explained that Johnson dealt only with the residual clause of the ACCA and did not discuss guidelines residual clauses. And it also noted that Davis, DeMaia, and Sims do nothing to undermine the holding previously set forth in the Brown case.
Sorry.
I mean, in one response that it's procedurally waived anyway, in terms of that question, it wasn't raised, was it? Direct. The question is, the challenge is to whether or not it was appropriate in terms of categorical approach at the sentencing aspect of it, right? Was that raised properly on the 2255? Is it waived here, that argument?
Your Honor, it was not raised properly on 2255. And so now
do we have jurisdiction to hear that argument question?
I don't think that you can raise the claim the appellant can raise the claim on 2255. So now I want to sort of briefly move to foot because that's sort of the realm we're in now.
Before you do that, you have waived, have you not, the timeliness of the 2255 motion?
Your Honor, the district court did not make a determination.
Did you raise it?
Based on timeliness, and the government did not raise that claim
okay, so
in the district court. But the defendant's claim initially, or the appellant's claim initially before the district court, did not contain a foot-based claim. All of the claims, and particularly the McCollum-based claim, was couched under a Davis residual clause claim in the first instance. So the district court was correct to deny based on Beckles, because the Davis claim is not viable in the first instance, and McCollum is dependent on Davis. And so now I want to move briefly to the court's decision in Foot, which the appellant claims was superseded by Davis. Foot held that a later nullified career offender designation failed to constitute a fundamental defect that inherently resulted in a complete miscarriage of justice, as is required for bringing a motion to vacate under 2255. Now, to be clear, the government's position here before the district court and on appeal is that no such error of law even occurred here, because the residual clause was valid at the time of the appellant's sentencing. But even if we assume some error, Foot's holding is controlling and requires denial. The appellant's erroneous career offender designation claim would fall squarely within Foot. And the appellant has no viable basis for his claims that Foot was somehow superseded by Davis, because first, Foot involved in an invalid career offender designation, and Davis involved the residual clause of Section 924C, and doesn't address the guidelines at all in its 17-page majority opinion. In that same vein, the defendant in Foot was challenging an advisory guidelines calculation, while the defendant in Davis was challenging a mandatory consecutive sentence imposed by statute. Put simply, these cases deal with completely different areas of sentencing. There is simply no way Davis has any impact on the ruling in Foot. And beyond that, Foot itself distinguished cases like Davis when it reasoned that guidelines errors cannot typically be miscarriages of justice because they are not mandatory on sentencing courts. And in an attempt to diminish Foot's applicability, the appellant asserts that Foot only deals with career offender designations that were later nullified, and his case deals with a career offender designation that was always incorrect. But his assertion in that regard, again, incorrectly assumes that there was an error in the first instance based on Davis. And regardless, it defies logic for the appellant to argue that Davis both supersedes Foot and is at the same time distinguishable from it. And I would like to also address one of Judge Wynn's questions to the appellant. And Judge Wynn had asked would conspiracy to commit murder in aid of racketeering qualify under the residual clause? And the clear answer to that, based on this court's prior decisions, is that it would. The court has held that where the object of a conspiracy offense is a crime against the person, that conspiracy is a dangerous type of crime that creates a serious potential risk of physical injury to another. And prior to Johnson and its progeny, the district courts regularly conducted ordinary case analysis under the residual clause. And Beckles tells us that there is no vagueness issue in doing so in the guidelines context. And the overall lesson of Foot is that the court is not permitted to revisit such determinations on 2255. In other words, there's not an issue of constitutional dimension here, because Beckles tells us that the advisory guidelines are not subject to attack on vagueness grounds. In other words, the level of certainty that the Constitution requires in identifying violent felonies and crimes of violence in the statutory context is not required for the guidelines.
But I understood, I hear you on that, but I understood that the argument from the other side was they're not relying on the vagueness unconstitutionality. They are relying on some other constitutional right that they glean from Davis.
I understand that as well, Your Honor, but there is no other right gleaned from Davis. Davis relied on the principles set forth in Johnson, and Johnson was based on a vagueness claim. And if the court believed that Johnson created some kind of other right, then if the Supreme Court believed this, it had the opportunity to decide so in Beckles, and it did not. It decided the opposite. And so I think that argument has no merit. So the issue in this case, it ultimately comes down to a simple question: whether the ruling in Davis entitles the appellant to relief from his career offender designation, and it does not. And the Supreme Court told us it does not in Beckles when it held that advisory sentencing guidelines are not subject to vagueness challenges under the Due Process Clause, and that 4B1.2A's residual clause in particular is not void for vagueness.
So tell me, it seems the defendant is contending that Davis invalidated the application of the ordinary case categorical approach to the residual clauses. You read Davis like that?
I do not, Your Honor. And this court's prior precedent and decisions in United States versus Mack, for instance, tells us that's not the case, as well as the Supreme Court's decision in Beckles. The residual clause prior to amendment of the career offender guidelines is still in full effect and applicable. And the appellant was sentenced in 2012, well before Amendment 798 of the career offender guidelines, which removed the residual clause, was made and put into effect. I just want to mention one more thing regarding Amendment 798. The Sentencing Commission, in subsequently promulgating Amendment 798, thereby deleting the residual clause under the current version of the career offender guideline, stated that it was doing it as a matter of policy. And it is the Sentencing Commission that has the authority to make Amendment 798 retroactive if it chooses to do so as a policy judgment. But the Sentencing Commission did not do so. It did not make the amendment retroactive, which indicates that the commission did not wish to change the way in which the residual clause of the career offender guideline was applied prior to its amendment. And so Beckles ultimately resolves this case, and the district court was correct to deny the appellant's motion to vacate based on that decision. And I see that my time is running short, so if there are no further questions from the panel, I will conclude with that.
Thank you, Mr. Sui.
Thank you.
Mr. Hogben, you've reserved some time.
May it please the court, I have three things I'd like to discuss on rebuttal. First, the government argues that the residual clause in our challenge today is a vagueness challenge. Mr. Fallon's relief does not require finding that the residual clause was void for vagueness. Specifically, that would be a definitional challenge and would be precluded by Beckles.
But you are left to rely on Davis to give you the relief you're seeking here, though. And it seems to be where their point is that the footprint of Davis is not big enough to cover what you want us to shoehorn now into this separate constitutional violation, which you say is a fundamental error. So you're right, you don't make the vagueness challenge, but you rely on a case that did rely on that. So how is it expanded to encompass your argument, which I think is a very good argument, but you have to tell us what is the law that would be a basis beyond the footprint of Davis to do so. And that's what I'm asking you on this time you have for rebuttal.
The categorical approach has its origins in Taylor versus United States in 1990 case, and this had its origins even before that in common law. It continued to be honed into a finer point, and that's how we get to United States versus Davis, where you have more than just a definitional look at what the residual clause means. You have on page 2325, the court telling us that this is an issue of a constitutional dimension, and that's important language because that language in 1974, Davis versus United States, is the higher bar for a fundamental defect. It's higher than
as the Chief Judge said, it's an issue of constitutional dimension because of vagueness. But what else does it say? What other, I just don't read anything in Davis that goes where you want to go.
Your Honor, as we have on page 2325, it's an issue of a constitutional dimension. You have the court looking at three different approaches. Before it gets into the definitional challenge, before it looks at vagueness, it's determining what approach district courts have to use. And we have them looking at the case specific, the ordinary, and the categorical. And the former two did not meet the constitutional demands, the procedural demands that we want in our justice system. Also, there are alternative grounds not through Davis. Specifically, Foote deals with a career offender designation that was originally determined correctly and then later changed by law.
Why does that make a difference?
It makes a difference because Mr. Fallon's sentence was incorrect from the day it was decided.
Right, but you could make, I think, an equal argument that it would be inequitable for the other person, the person who's was illegal to begin with. I mean, I just don't see anything in Foote that would give us a basis for making that distinction.
Well, Foote itself discusses that this was an issue of a later determined to be error. And Foote has his issue from day one. The failure to use categorical approach would existed in common law and was refined. I
understand that.
And that is where the differentiation, the factual differentiation between Foote relies.
Yes, but why does that make a legal difference?
It makes a legal difference because otherwise Foote would preclude Mr. Fallon's challenge.
Right.
And so the fact that it has a large factual difference, the fact that the policy itself arrived at, the policy holdings that you see underpinning Foote are not met here because this is not a later invalidated sentence. This was a sentence that was wrong from day one. A third point, I'd like to address the government's timeliness remarks. The government argues that because Mr. Davis's argument has been refined to a finer point here at the appellate level, that he can raise the argument of timeliness again. In the text of their brief, nowhere is a timeliness argument. Rather, it's relegated to a footnote. And this court's precedent in Wahi versus Charleston Area Medical Center tells us that placing an argument in a footnote constitutes waiver, and the fact that it was relegated to a footnote shows its overall weakness. Additionally, the government wants to argue that Mr. Fallon is raising new arguments on appeal. This court has held the petitions of a pro se petitioner, of which Mr. Fallon was at the district court level, are construed liberally and to be interpreted to raise the strongest arguments they suggest. And Mr. Fallon raised Davis at the district court level, and this court's precedent is U.S. versus Mayhew, a 2021 case. I see that I'm out of time.
Well, you can finish your thought. Go ahead.
Failure to grant Mr. Fallon's requested relief would undermine the categorical approach, and it would leave Mr. Fallon the victim of a complete miscarriage of justice. Thank you.
Thank you, Mr. Hogben, and thank you, Mr. Sui. Mr. Rosenberg and Mr. Hogben, we want to make a special note because you're court appointed, and our court depends a great deal upon the lawyers like yourselves who come here and help us through these thorny issues. And I say you acquitted yourself very well in West Virginia and Mountaineers, and appreciate your being here. And also, Mr. Sui, thank you for your representation ably of the United States. We would love to come down and greet you as we're in our normal tradition, but we can't under the circumstances. But no, nonetheless, we appreciate your being here. We wish you well and be safe. Thank you. You can stand at ease while the clerk releases the court. She'll take care of that. You can take that off. Go ahead. Ms. Taylor?
Yes, Your Honor. Good morning.
Good morning.
Good morning, Your Honors.
Morning.
Laura Taylor on behalf of the United States. Just for the record, I'm on the briefs as Laura Rottenborn. I was recently married and I am yet to change my name. So I just
Best
wanted
wishes
clarify
to you.
that. Thank
Best
you very
wishes
much.
to
I appreciate that, Your Honors. I'm here this morning on behalf of the United States and may it please the court. This court should reinstate the indictment against Mr. Sanchez because under this court's decision in Herrera Pagoda, Mr. Sanchez's collateral attack on his prior 2011 removal order must fail as a matter of law. The only prong of Mr. Sanchez's collateral attack under Section 1326D that's at issue in this case is the third prong, known as fundamental unfairness. And to prove fundamental unfairness, Mr. Sanchez bears the burden of proving both a due process violation, and that's a violation of the Due Process Clause of the Fifth Amendment of the Constitution, and prejudice that results directly from that due process violation. Below in the district court, Mr. Sanchez alleged only one prejudicial due process violation, and that was an alleged violation by the immigration judge by not advising Mr. Sanchez of the possibility of voluntary departure. This court in Herrera Pagoda, and specifically Judges Diaz, Floyd, and King, held that an immigration judge's failure to advise regarding voluntary departure is not a due process violation as a matter of law. That holding controls this case, resolves this case, requires reversal and reinstatement of the indictment. More specifically, Herrera Pagoda confirmed three things relevant to this appeal. The first legal principle that Herrera Pagoda confirmed is that in order to successfully launch a collateral attack under 1326D and the third prong, fundamental unfairness, the alien must show a due process violation, that is, a violation of the Fifth Amendment's Due Process Clause. A statutory failing by the immigration judge does not automatically rise to the level of a due process violation. And as a result, because here, failure to advise an alien at a removal proceeding regarding voluntary departure is not a violation of the Due Process Clause of the Fifth Amendment. There can be no
violation of indicating the individual had, Mr. Bernays had waived his appeal rights when you hadn't actually discussed that with him.
Yes, Your Honor. Now, of course, below in the district court, that was not the basis for the motion to dismiss the indictment.
Does it have to be? I mean, can't we look at this and look at the record as a whole and determine as to whether we should affirm it on any basis that we find in the record?
Yes, of course.
What does it matter whether he raised it low?
In order to establish fundamental unfairness, Mr.
In
Sanchez.
terms of waiver, does it matter really on that? We can decide it on that basis, is what I'm saying.
It does matter because Your Honor should not decide it on that basis because fundamental unfairness requires two findings, both a due process violation and prejudice. And so to the extent this court wished to address whether failure to advise an alien regarding his appellate rights amounts to a due process violation, there still is nothing in the record to reach the second prong regarding prejudice because
you rely on prejudice for that particular argument, not the question of whether it's a due process violation.
the government believes that it has good arguments on both prongs, but the prejudice prong is clearly established. There is absolutely no prejudice to Mr. Sanchez as it relates to any failure to advise regarding Mr. Sanchez's appellate rights. But moreover, in Herrera Pagoda, that court also addressed this exact issue. And it stated in Herrera Pagoda, excuse me, that even if an IJ's failure to explain voluntary departure were to effectively deprive an alien of the opportunity to appeal, that also does not mean that the removal hearing violated due process. So with respect to the first prong of fundamental unfairness, whether there's a due process violation, the Herrera Pagoda court answered that question in the negative.
I don't know that I disagree with you, but I didn't see that argued in your brief. I thought that it was really quite extraordinary that you didn't talk about prejudice in your brief. I mean, you didn't talk about the due process violation. You talked about the other elements. So maybe you could show me where you said that this wasn't a due process violation in your brief.
Yes, Your Honor. And forgive me, because I know there are many briefs in this case as a result of the supplemental briefing.
Yeah, I think that's what I was looking at.
Yes, Your Honor.
You're right. There are so many. I keep reading the wrong ones.
Bear with me
Remember
just
the
one
people on
moment.
The other side also commented on that you hadn't even challenged whether or not this was a due process violation.
Yes, well, we do challenge that, Your Honor. On
And-
page 3 of our supplemental reply brief, we discuss how Sanchez's argument regarding the fact that failure to advise of an appellate right regarding voluntary departure is a circular argument that collapses back into an iteration of the prior argument, that the IJ was supposed to, under the due process clause, tell Mr. Sanchez about voluntary departure. And therefore, he should have also told him that he could appeal a denial of such undisclosed voluntary departure. And it's the government's position that neither of those is required under the due process clause of the Constitution. Now, I certainly acknowledge, Your Honor, that we spent the vast majority of our reply brief addressing prejudice. And that's because the district court below stated very clearly in his opinion that although Mr. Sanchez raised the issue of appellate rights, Mr. Sanchez had not alleged in the district court that failure to advise about the appellate rights was indeed prejudicial. He had not alleged that.
Can you tell me where you say that? I'm looking at, I think, the right brief, supplemental briefs of the United States.
I am, yes, in front of me, I have our reply supplemental brief. And I
I thought you told me.
Yes.
Okay.
Pages
Supplemental reply brief now.
Supplemental reply brief, yes, Your Honor. And this is in part because
Just tell me the page.
page 3, page 3.
Okay, now go ahead and make your argument.
Yes, so the sentence that I quoted earlier is at the very top of page 3, and then the government goes on to say, if the IJ has no constitutional duty to inform the alien about the possibility of applying for voluntary departure under Herrera-Pagoda, then there cannot be an error of constitutional dimension in failing to inform the alien that he can appeal the alleged failure to inform. In other words, it does not amount to a violation of the due process clause. It's not an error of constitutional dimension. And then the government goes on in its brief to say, and moreover, Mr. Sanchez could not establish prejudice. And then we spend
Yes, but the first sentence that you're relying on is if the IJ has no constitutional duty, but you don't say the IJ has no constitutional duty.
Because the IJ has no constitutional duty to inform the alien about the possibility of applying for voluntary departure, as this court held in Herrera-Pagoda, then therefore, the second part of the sentence, it cannot be an error as a matter of law.
Okay, maybe not so quick, and just tell me what you're quoting from, because I don't see that language. I don't see the because.
Okay, the first full paragraph on page 3.
Right, which it says, but if the IJ has no constitutional duty to inform the alien about the possibility of applying for voluntary procedure under Herrera-Pagoda, but you don't say, okay, all right, I hear what you're saying.
It says, I guess that there.
You could have phrased it a little more.
I could have put a therefore instead of a yes, Your Honor.
All right.
Yes, Your Honor. The government's position is that there cannot be an error of constitutional dimension, an error that fails the due process clause of the Fifth Amendment by failing to inform an alien that he can appeal the alleged failure to inform about voluntary departure if there was no constitutional requirement to inform the alien about that in the first place. That it's a logical and non sequitur.
Why did you wait to the supplemental reply brief to say that?
Well, Your Honor, this is a byproduct of the evolution of the issues in this case. Mr. Sanchez did not raise this issue in the district court. The district court specifically stated in his opinion that Mr. Sanchez did not raise this issue. The government is the appellant. It focused on the only issue that Mr. Sanchez did raise, which was whether or not there is a due process right to be advised of voluntary departure at a removal hearing. So the government spent the vast majority of its brief outlining all of the various case law from the other circuits on that very specific and important issue of law. After the government's brief was filed in that case, Herrera-Pagoda came out, and this case was stayed for reasons unrelated to Herrera-Pagoda. Herrera-Pagoda was then decided in the meantime and answered the question that was presented in the government's opening brief. So essentially what happened is that the entire substance of the government's opening brief was resolved by the Herrera-Pagoda decision. And then Mr. Sanchez pivoted.
They conceded that. Isn't that sort of conceded here?
Yes.
So, that's why I focused on this alternative argument. that
Yes.
deals with the appeal waiver and the fact that the district court did that and didn't even discuss it. You say, well, even if you deal with the first prong of it, there's a prejudicial side of it. And I'm wondering, you going there, does that mean we now send it back for the district court in the first instance to address that presidential prong?
No, Your Honor, that would not be necessary because you don't reach
Not
prejudice
necessary, but can we do it?
only if you find that there was also a due process violation. It requires
That's
both.
the first instance. The first instance is, I thought we discussed that if we determine it is a due process violation for the judge to indicate you waive your appellate right, yet the record indicates he didn't even discuss the appeals with him. That looks like a due process right violation, which then you slid into what you say is really the big argument is prejudice. So send it back and let the trial judge determine prejudice in the first instance. Problem?
We would certainly agree that if you reach the prejudice prong, that you could send it back for a decision on prejudice as it related to a failure to advise of an appellate right. We don't think on this record that's necessary because there is no evidence whatsoever in the record of prejudice. The prejudice record was already developed as it related to Mr.
Well, I want to
Sanchez's
stick
first
to due
complaint.
process. You said we don't get to prejudice unless we deal with that. You started out, and I thought we could probably agree that if a trial judge says you waived a right and you didn't even discuss it, that's a due process violation. The question then goes to the prejudice, and while we can look at the record and gleam and go through it, that's kind of what we let trial judges do and trial forums to do. So we send it back.
Yes, Your Honor, except that Herrera-Pagoda specifically addresses the question about appellate rights rising to the level of a due process violation in the context of voluntary departure, and it rejects that notion. The Herrera-Pagoda court specifically held that an IJ's failure to explain voluntary departure, even if it effectively deprives the alien of the opportunity to appeal, does not by itself mean that the underlying removal hearing violated the due process rights. So, and then it goes on to quote this court's prior decision in Wilson, which likewise held that there's no constitutional due process right to discretionary relief. And the Wilson court emphasized that a collateral attack on a Section 1326 prosecution is available when the original deportation proceedings were both fundamentally unfair, that's the prong at issue here, and resulted in a denial of judicial review, noting that these are, quote, separate requirements.
So looking at the prejudice question, El Shaman is a case we had. I seem to recall we said that it's rather speculative to go looking in the record, seeing whether something is prejudicial or not. Again, going to the question of why not send it back?
Because in this case on collateral review, it's Mr. Sanchez's burden to prove prejudice. He had that opportunity in the district court. He chose not to present any evidence. In other cases, the alien will testify or there might be an evidentiary hearing. But in our case, Mr. Sanchez presented no evidence to the district court that is now available to this court on appellate review to find that he was prejudiced. It's not the government's burden to show that he was not prejudiced. It's Mr. Sanchez's burden to prove prejudice. And he has not carried that burden, and he has not attempted to carry that burden. And the prejudice prong existed from the inception of this motion to dismiss, because Mr. Sanchez moved to dismiss his indictment originally based on the failure to advise of voluntary departure, claiming that was prejudicial. This court has before it all of those arguments. Mr. Sanchez did not carry his burden. He put forth no evidence in 2018 or 2011 as to how any of this was prejudicial to him. And so there would be no need to revisit that issue on remand in this
Ms. Taylor, wasn't there some problems here with, we got involved with the discussion about could he afford voluntary departure and did he have the money and all those things? Was that really appropriate? Is that the business of the court? I mean, you can be offered the opportunity to voluntarily report. Maybe somebody may loan him the money. Maybe a gift. Hit the lottery or what? Why should that be? If he could appeal, then that may have been resolved. Wasn't that error to even? Why would that have to do with it at all?
The reason it matters now is because of the.
No, not then. I'm talking about then. Why was it then really an issue? What being impecunious person, what did that have to do with it?
Whether or not an alien has the financial means to actually depart the country matters in a removal proceeding because voluntary departure must be at the alien's expense.
Right.
And if you're in a post-conclusion posture, the alien has to actually have to prove that he can in fact pay to depart. In a pre-conclusion voluntary departure posture, that inquiry is not necessary. But here, the immigration judge asked the alien, do you have the means to depart? The alien said he did not have the means to depart. He did not have money to travel back to Mexico from Virginia. The reason that matters now on collateral review is that it's Mr. Sanchez's burden to prove that he actually would not have been deported, or that there's a reasonable probability he would not have been deported. And if he didn't have the money to depart, then he's not going to be able to carry his burden of showing that he wouldn't have been deported. Because if the immigration judge had entered voluntary departure and Mr. Sanchez could not afford to actually leave, then automatically, by operation of law, the removal order comes into effect and Mr. Sanchez is ordered deported. So in order to avoid the deportation order, Mr. Sanchez has to pay for his own departure from the United States under his own theory of voluntary departure. And here, where it's his burden to prove prejudice, it's his burden to show evidence that he would have actually done that. The fact that the only evidence in the record is that he said he had no money, he had no financial means, shows that he cannot carry his burden now on collateral review. I see that my time is up, and I will reserve the remainder of my time for rebuttal unless the panel has any further questions at this time. Thank you.
Thank you. Ms. Trotton?
Can I ask you a question at the very outset? Because it was an argument that you raised in your brief. If, as I understand it, you have to show that there's a due process violation and that there was prejudice, right?
Yes, Your
To
Honor.
show both of those.
Yes.
Okay. And what you said pretty consistently in your brief, they haven't even claimed there's a due process violation. And now we have looked at page 3 of their supplemental reply brief. And you never had a chance to respond to that, I don't think. So tell me why that isn't an assertion of this is no due process violation.
Well, Your Honor, this is not a due process violation because under the government's rationale, if that were correct, that would countermand this court's prior approach to due process violations. It would allow the treatment of discretionary relief to swallow any due process protections.
Well, that's what we seem to say, though, in Herrera-Pagada.
Herrera-Paguada is actually much narrower than that, Your Honor. What Herrera-Paguada says is that an alien has no due process entitlement to be advised of the possibility for voluntary departure. But if you look at the court's—
I thought that the rationale of that was all about the fact that this wasn't, that this was all within the discretion of the government, and therefore you didn't have the right, in the same way that this would be within the discretion. The right asserted here is within the discretion of the government.
That's actually never how this court or other courts have approached that question, Your Honor.
Not until Herrera-Pagada.
Well, to the degree that Herrera-Paguada is in conflict with prior decisions of this court, the prior decisions would control under the rule in United States versus McMillan.
Well, that's true, but I don't think you have to look at the specific statute that is being, and I don't think there's anything that is in conflict with regard to this specific statute, so that you wouldn't get to the prior precedent overruling the new precedent when they're dealing with different statutes.
Your Honor, I think the difference is that the rationale in Herrera-Paguada is, although the government attempts to expand it more broadly, is actually quite narrowly limited to that alien's only claimed issue was, his only claimed due process violation was the denial of being advised of his eligibility for voluntary departure. Now, that was a claim that we raised below. That was the primary claim we relied on below. It was not the only claim we relied on below. And in fact, looking at both the oral argument and the briefing below, the court can see that we did raise the issue of the denial of the appeal right previously.
And I agree with you on all of that, but it seems to me that they both fit under the same category, that they're dealing with not a thing of right, but a discretionary.
Most forms of relief from removal are discretionary. So when we look at this, this is not a narrow category of cases. In El Shami, which is this court's primary decision on that, the form of relief at issue was 212C relief, which is discretionary. Yet that did not invalidate Mr. El Shami's right to receive notice of his hearing. And I think, Your Honor, your concurrence in Wilson addressed this problem where you point out that the discretionary relief is not the problem here, and that's as in Mendoza Lopez, the very relief at issue there was discretionary. So certainly these cases do not stand for, and Herrera Paguada does not stand for the proposition that aliens have no due process rights where the relief at issue is discretionary. That would stand.
I thought that was the rationale for it didn't say it didn't say it in those bold, but the holding there is based on the fact that it was discretionary relief, I thought.
It was, Your Honor, but that certainly is in conflict with this court's prior decisions, and I think it should be interpreted narrowly to the circumstances of Herrera Paguada. Certainly here.
The problem is that case is pretty close to this. I mean, you just told me a minute ago you made the same argument originally, and well, you did. You have two arguments. I don't doubt I'm not disputing that.
Right.
But it's pretty close.
It's similar, Your Honor, but
they'd have to re-indict him. I guess that's right. But I would think that you would rather have him re-indicted and get some of the relief that you think that he would be entitled to, and then maybe clear this all together than to have us just affirm here.
If the court is inclined if the court feels that there's an insufficient factual basis to find prejudice, if I'm understanding the court's concern correctly, that's the issue here, I think that we do fall within the rubric of Quintero and under those circumstances, and that the court should presume prejudice rather than sending it back. Because this is exactly the same situation as in Vasquez-Flores. That's what this court did in Vasquez-Flores. As a practical matter.
What if we think it's also unclear whether or not the government asserted that there was the violation of constitutional right here?
Well, if the government isn't challenging the violation.
No, I didn't say that. Maybe they did challenge it. Maybe they didn't. We can't tell.
Mm-hmm. The government has certainly had the opportunity to assert the violation of constitutional rights.
Right, and they have done that in their reply brief, their supplemental reply brief. But I thought you and I just had a dialogue about we don't do that. Right. We don't recognize those. So it seems to me there's just a lot of things that would benefit from a remand here.
This case was dismissed more than 2 years ago at this point. Since that time, there's been no case pending against Mr. Sanchez. He's been living his life and pursuing immigration remedies, as the court can see from the final docket entries where his discovery order was permitted to allow his attorney to view his A file that was received in discovery in this case. Reinstating from a practical point of view, reinstating the indictment against him at this point likely would cause difficulties with his immigration case. So from a individual human perspective, I think that is one concern that we have. But I think the court doesn't need to do that because the record is sufficient right now for the court to determine that the district judge had it right. And that reviewing the district judge's findings for clear error, there is no clear error in the factual findings as to prejudice.
Well, the question of the indictment is interesting, and I'm wondering if we send it back for limited remand, retain the jurisdiction, do we need a new indictment?
I honestly don't know the answer to that question, Your Honor.
Well, we're a court. You can probably do it.
Well, and as you argue, the record itself may contain enough information on it. I mean, something we'll have to look at. And you also seem to indicate that evidence would come even because the prejudice prong from the original argument still is there, at least, and this did put a finding there before us. So, I mean, it's possible we could do it on record. I'm not saying it will be done. I thought the indictment question was a very good one and interesting.
I agree, Your Honor. Unless the court has any other questions, thank you.
Thank you. Ms. Taylor?
Thank you, Your Honor. Prejudice in this case must link to a due process violation. Therefore, the first question is whether or not there was a due process violation in Mr. Sanchez's removal proceedings. The only due process violation that was at issue in the proceedings below was the alleged failure to advise regarding voluntary departure. Judge Moon specifically said that Mr. Sanchez did not claim a prejudicial due process violation from a failure to be advised of his appellate rights. Judge Moon issued an order only on the issue of failing to advise of voluntary departure, and the government took an affirmative appeal of that decision. And that's why the government's opening brief does not talk about the appellate right issue, because Judge Moon specifically said that Mr. Sanchez did not raise that as a prejudicial due process violation. Of course, a lot of time has passed since the government's opening brief, and in that time was the intervening Herrera-Pagoda decision. This court ordered supplemental briefing regarding that decision. And then Mr. Sanchez raised in his supplemental brief this new argument, this goalpost moving argument, where he pivots and says, all right, we concede that Herrera-Pagoda is dispositive of the issue on appeal that the government has raised. However, we're now going to make this alternative argument about failure to advise of appellate rights being a separate due process violation resulting in prejudice. And the government responded to that argument in its supplemental reply brief, arguing both that that is not a due process violation, and even if it were, there is no resulting prejudice. So in this case, the court must first decide, one, whether or not Judge Moon's opinion holding that there was a due process violation regarding failure to advise voluntary departure was or was not correct. And under Herrera-Pagoda, it clearly was incorrect and needs to be reversed. The next question then would be, is there anything left to decide? To the extent that Mr. Sanchez is also asking this court to decide the question about failure to advise of appellate rights, then that question is also squarely answered in Herrera-Pagoda, because the court there said that failure to advise of appellate rights is a separate requirement. It goes to the prong of 1326D regarding an opportunity for meaningful judicial review, quoting the Wilson decision. And that, as I stated before, that just because a failure to advise regarding voluntary departure may effectively or derivatively deprive an alien of an opportunity to appeal on that issue does not amount to a due process violation. And that would be the end of this case. Because there's no due process violation, the court never needs to visit the issue of prejudice. Of course, as in all of these— I
wish you'd said all that in your brief.
Appreciate that, Your Honor, and we will learn from that.
But is that the only issue, though? I asked you about it. You said, do you disagree with what Ms. Troughton said about the being able to afford to voluntarily? She said it's not. You disagree with that?
I'm so sorry, Your Honor.
I disagree that you have to show that you have the money to leave. That's a requirement.
At the time of the removal hearing or now on collateral review, Your Honor?
At the time of the hearing.
At the time of the removal hearing, it was not a requirement for Mr. Sanchez to prove that he had the financial means to depart. I would agree with Ms. Troughton on that completely.
But that's when we look at it. Isn't that the time to look at it in terms of what the effect of an appeal would be? That issue could have been raised as well as the one of whether or not you're being told about. Why isn't it any bigger than that? There are other issues.
Yeah, respectfully, no, Your Honor, we disagree with that point. So if I understand Mr. Sanchez's argument on this correctly, essentially what he's saying is, we admit that there was no obligation for the immigration judge to tell us about voluntary departure. But he should have told me that I could have appealed not getting voluntary departure, which of course does not logically follow. But even if the immigration judge had simply told Mr. Sanchez generically, you can appeal. If Mr. Sanchez had actually appealed his removal order on anything other than voluntary departure, then by operation of law, he no longer qualifies for voluntary departure. because you only get voluntary departure if you waive your appellate rights. And so the only thing that Mr. Sanchez could have appealed would have been not getting voluntary departure. But that becomes a house of cards and collapses on itself, because how could he have appealed not getting voluntary departure if there was no constitutional obligation to advise him of voluntary departure? And so it becomes wholly speculative by Mr. Sanchez. It is a red herring that he would have appealed the IJ's decision, gone up to the BIA.
How can you say categorically that's the only thing he could appeal? What about the issues about many things he may have been able to appeal in terms of due process issues?
But if he had appealed anything else other than his voluntary departure eligibility, then he no longer is eligible for voluntary departure. Because in order to reap the benefit, the privilege of voluntary departure under the regulations, you must waive your right to appeal all other issues. And so once he takes an appeal on something else related to his removal order, which he didn't do in this case, but hypothetically, if he were to have done so, then he would no longer be eligible for voluntary departure. And so we have a very circular argument by Mr. Sanchez saying, yes, we understand that he didn't have to advise us of voluntary departure, but he should have told me I could have appealed that non-disclosure, because then I could have gone up to the BIA and wholly speculatively, maybe the BIA would have told me, hey, you should apply for voluntary departure.
So you're saying that the Fourth Circuit, we have no jurisdiction to handle anything in regard to voluntary departure at this point from an appellate standard. That's what you just said. Categorically, we're out of the game completely.
I certainly do not think you're stripped of jurisdiction to resolve the issue. No, Your Honor, I did not mean to go that far.
What's left for us to do, the power to do based on your argument?
So on collateral review, in the context of collaterally attacking an illegal reentry indictment, only in this context, I am not at all opining on this court's appropriate involvement in a direct BIA appeal. That would be an entirely different context. But in the context of a 1326D collateral attack, it is Mr. Sanchez's burden to first establish a constitutional due process violation. And here, this court should hold, consistent with Herrera-Pagoda, that there is no due process violation on the facts and the law of this case.
Yeah, when you're talking about putting somebody in prison, that's different than the context of immigration law. This is a question about, it reaches to the heart of what due processes and justice is. You're indicting him for the penalty of his liberty, right? This is a criminal charge, right?
Yes, Your Honor, absolutely.
And we talk about discretion. It's sort of almost a fiction, even in asylum cases. Even if we found the most egregious violations, am I right? We can't force the Attorney General to give anybody asylum. Is that right?
I understand that to be correct, Your Honor.
That's sort of, so that's almost, that in itself is a fiction in a sense. But we don't handle it that way. We look at constitutional questions and due process issues. And you're saying we can just, if a person indicted, well, it doesn't make a difference where he can't. But we presume that when you lose your right to appeal, that is important, that is prejudicial. Because we can't sit here and say we don't know what the mind is, a beautiful, wonderful, creative thing in terms of law. But you're saying that's the only thing it could be, and therefore he's left to the district court looked at this matter, and said no, this was wrong, and an indictment violated our principles of fairness in that situation.
I certainly appreciate the spirit of your question and agree with you very much that if the government is presented with a case where an underlying removal order is invalid, or there are genuine concerns about that underlying removal order, the government needs to exercise its discretion and tread carefully with a subsequent illegal reentry indictment. I absolutely agree.
Yes, but the rule of law does not require the hand of mercy of the executive branch. It is a question of whether or not this court, in terms of its obligation to make sure justice is maintained. So you're saying, well, if we find the hand of mercy, but that's the whole idea of separation of powers. And when it comes to criminal convictions, we're not talking about it solely it's full discretion in the executive branch, but not when you're talking about indicting somebody in a criminal case. And that's what the district court was looking at.
Yes, Your Honor. And absolutely, this court should very much employ its powers and responsibilities to determine whether or not there was a due process violation in the prior removal proceeding. We full-heartedly agree with that. As a matter of law, however, in this case, there was no due process violation in Mr. Sanchez's prior proceedings. And so they don't constitute fundamentally unfair proceedings. Had there been a due process violation, the government would absolutely acknowledge that the proceedings were fundamentally unfair and would concede the collateral attack in this illegal reentry indictment. But here, Mr. Sanchez's prior removal proceeding did not violate the due process clause of the Fifth Amendment, and therefore it doesn't constitute as a matter of law a violation of 1326D. And therefore, Mr. Sanchez's collateral attack must fail as a matter of law. And for that reason, we would ask that the district court's decision be reversed and the indictment be reinstated.
Thank you so much.
Thank you, Your Honors.
Ms. Taylor, Ms. Troughton, for your arguments. Appreciate it very much. We can't come down and shake your hand as we would like to do, but know very much that we appreciate your arguments and your presentation today. Thank you.
Thank you very much for your time.
Thank you. Absolutely, yeah.
Just really.
Well done.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
See it? Yes. Mr. Winograd?
Thank you, Your Honors, and may it please the court. The question in this case is whether the board erred by failing to order a new hearing before a different immigration judge. The court should hold that it did for two reasons. First, the board proceeded on the assumption that my client was required to establish a due process violation to receive such a hearing, when under matter of YSLC, he was not required to establish a due process violation. Second, and even assuming that he was required to establish due process violation, he was deprived of a fair hearing because the immigration judge abandoned her role as a neutral adjudicator. Unless the court prefers otherwise, I will address the arguments in that order. Now, there is no question that the due process clause establishes the floor when it comes to measuring the fairness of a removal hearing. But the board, of course, can elect to hold immigration judges to a higher standard of conduct. And that is what the board did in matter of YSLC, which found that a new hearing was warranted because the IJ did not comport himself in a manner that met the, quote, high standards expected of immigration judges. Now, conceitedly, the board did not elaborate on what those standards are, but the facts of the case make clear that a due process violation is not required for a non-citizen to receive a new hearing. And we know this because at no point in matter, yes.
So what is the basis for YSLC?
Oh, well, we believe the board has supervisory power in order to set a higher standard in determining when an immigration judge's conduct crosses the proverbial line.
Can you give me some other cases where they've done that? I think maybe you're right, but
well, a matter of
not YSLC type cases, but other cases where there is some administrative authority that affects an actual decision.
Well, there is certainly a slew of unpublished decisions, but other than matter of YSLC, the board has not spoken again in a precedential decision in a case involving a claim that an immigration judge, that an immigration judge's misconduct by itself warranted a new hearing.
Well, any other, it doesn't have to be this particular fact situation, but any other time where you see the board using some sort of administrative authority to give relief to a person.
Sure. Well, there have been a slew of unpublished decisions, which I could.
How about published?
No, conceitedly, there have not been any other published decisions. I would concede that. But we think YSLC establishes that no due process violation is required because at no point in that decision did the board find that the non-citizen either had been deprived of a fair hearing or that he suffered any prejudice. And frankly, I don't think any court would find that the conduct in YSLC violated due process. The conduct had nothing to do with the merits of the case, and it was limited to a single exchange in which the IJ facetiously pretended that the non-citizen was an expert witness. And the board said that the non-citizen was entitled to a new hearing simply because of the insensitive and belittling nature of the IJ's remarks, and regardless of whether he was ultimately found to qualify for relief from removal.
A lot of the opinions that YSLC cites are due process opinions.
Some of them are, but I would note that the two cases that it cites immediately after the proposition in question, that would be, I'm looking on page 691 of the decision, and it cites the Second Circuit's decision in Ali and the Third Circuit's decision in Sukhwan Putra. Those decisions mention due process, but neither of them made any finding with regard to prejudice, which of course is required in the due process analysis. But I think the clearest reason why a due process violation is not required for the board to order a new hearing is that it would prevent the Department of Homeland Security from ever receiving a new hearing if an IJ belittled one of its attorneys or witnesses. And that is because the due process clause only protects private individuals from government misconduct. It does not protect the government from government misconduct. So if the board could only order a new hearing,
I'm not sure the government should be protected from government misconduct.
Well, I think certainly if an IJ belittled a DHS attorney, I would think that DHS would be within its rights to ask the board for a new hearing if the same conduct would entitle an alien to a new hearing. I certainly agree that the due process clause does not protect the government, but if that was the rule, then DHS would have no recourse in any case. Now, the government, for its part, does not dispute that the board can hold IJs to a higher standard of conduct than due process requires, and it does not contend that matter of YSLC requires a due process violation or that the IJ's conduct in that case violated due process. The only argument it really makes on this front is that the IJ's conduct in this case was not as bad as the conduct in YSLC. But as I said at the outset, the board in this case did not acknowledge YSLC, and it instead retreated our request for a new hearing as a due process claim. So we think under the ordinary remand rule, the best course of action would be for this court to remand the record to allow the board to address our claim under YSLC in the first instance. But if the court does wish to reach the merits, we would ask it to find that the IJ's misconduct in this case was at least as egregious as the misconduct in YSLC. And that is so both because of the outburst during the hearing and because of the IJ's actions following the hearing. So with respect to the outburst during the hearing, we think the IJ's remarks were even more belittling than those in YSLC. After my client testified about his diminished fluency in the Spanish language, the IJ cut him off to say she found his testimony, quote, so incredible it's laughable. And then she later told his attorney, quote, I don't even know why you went there. I mean, it sounds so stupid, honest to God. So, Your Honors, whatever these standards expected of IJs are, they do not permit them to insult the intelligence of people in their courtroom. Judges, of course, are not required to extend the same courtesy to litigants that litigants are required to extend to judges. But there is still a line that judges cannot cross, and we think the IJ crossed it in this case. And contrary to what the government suggests, we think it makes no difference that matter of YSLC involved a minor. IJs, of course, should be particularly sensitive in cases involving minors, but the board said in YSLC that the IJ's conduct would have been inappropriate towards any non-citizen. So the board itself did not view the minor's age as dispositive. If the court has no additional questions about the YSLC claim, our second argument is that the IJ's conduct.
The question I have is, to what extent did you really raise that issue?
The YSLC claim?
You didn't really raise it, the standalone YSLC issue in your brief. What you seem to say is it's well settled that the aliens inside the United States are protected by due process.
Well, we certainly did cite YSLC in our brief to the board. I can see that our primary argument was that the board should simply grant my client's application on the merits, and that was as a practical matter. My client had already been detained for nearly 2 years at that point. So the ultimate goal was to have him receive relief rather than to be remanded for another hearing and potentially another 2 years.
And you did this below?
I'm sorry?
You did all this below?
Yes. Well, we certainly said that a new hearing is warranted under matter of YSLC. And even in the conclusion of our brief, we said, after asking the board to sustain the appeal and reverse the denial of cancellation, we said, alternatively, the board should remand the record for further consideration of respondent's application by a different immigration judge. And we did there. I can provide the pin site on rebuttal, but we certainly did ask for a new hearing under YSLC. With respect to the due process claim, I would like to just clarify at the outset the precise nature of the due process violation that we're alleging. We do believe that the IJ violated due process by ultimately considering the police report, but the claim we're making in this case is that the IJ abandoned her role as a neutral adjudicator by seeking out the police report in the first place. So to see the distinction, just imagine that the police report was placed in the record due to a clerical mistake, and the IJ relied on it without realizing that it had never been submitted into evidence. In that scenario, we could still argue that due process was violated by the consideration of the report, but we could not make a claim that the IJ abandoned her role, abandoned her neutrality by seeking the evidence out. But in this case, of course, the IJ did affirmatively seek out the evidence, and by definition, a judge who goes affirmatively looking for evidence has abandoned their role as a neutral adjudicator. And we think the fact that the IJ abandoned their role as a neutral adjudicator was only confirmed by the fact that she failed to even notify my client that she intended, to consider the police report or give him an opportunity to respond.
The government says you are not entitled to due process rights because the cancellation of removal is discretionary. How do you respond to that?
Thank you, Your Honor. While this court has held that non-citizens cannot raise due process challenges to statutes involving discretionary relief, and while it held that non-citizens do not have a due process right to be informed of discretionary relief, it has never held that non-citizens who have sought discretionary relief cannot raise due process claims with regard to the procedures used in their specific case. To the contrary, in at least 3 cases, Rusu in 2002, Anim in 2008, and Atemkem in 2020, this court has considered due process challenges to the denial of asylum, which of course is also a discretionary form of relief. And I think if the government's argument was correct, it would mean that aliens applying for cancellation of removal, asylum, or any other form of discretionary relief could not raise any challenge whatsoever to the neutrality of the immigration judge under any circumstances, even if, for example, the immigration judge used a racial epithet during the hearing, or even if they had a blatant conflict of interest, such as being married to the prosecutor for DHS. And we think that simply cannot be the correct rule. So we would ask this court to clarify that non-citizens seeking discretionary relief can challenge the procedures used in their cases no less than any other non-citizen can.
We wouldn't have to go there, would we? Because your answer to, excuse me, one of my earlier questions about what would be the basis for this rule if it wasn't the due process clause, remember?
Yes, certainly. Yeah, certainly. If the court resolves, the court doesn't need to reach the due process claim if it grants our first argument involving matter of YSLC.
Right.
But if the court does reach the due process claim, the question would be prejudice. And we would ask the court to find that my client was prejudiced. Now, the government claims that he was not prejudiced because the board did not consider the police reports at issue, and it upheld the IJ's decision after applying de novo review. But we think the former argument is irrelevant and the latter argument is incorrect. Because our due process claim is not tied to consideration of the police report as such, it does not matter whether the board considered the police report. All that matters is whether the IJ served as a neutral adjudicator. And the Supreme Court has held that a neutral appellate body cannot cure prejudice arising from a child judge who is not neutral. That's from the Monroeville case, which we cite in our briefs. But in any event, the board did not truly make an independent determination in this case with regard to my client's application. While it did apply de novo review to the IJ's ultimate discretionary determination, it applied clear error review to her factual findings, including the finding that there was a possibility that my client could relapse. So the government cannot claim that my client suffered no prejudice from the IJ's failure to serve as a neutral adjudicator when the board deferred to the factual findings of the same IJ whose neutrality is in dispute. And so if the court agrees that the board's determination did not itself cure any prejudice, the only question is whether there is a reasonable probability that a different IJ would have granted my client's application. And on that question, the government doesn't dispute that there is such a probability. Although my client has a serious criminal record, he also has extensive positive equities, including 3 U.S. citizen children. And most importantly, before the IJ reviewed the police reports, she said at the end of the hearing that her decision could go either way. So we think this is a case where the record makes clear that there was prejudice. Now, one argument we considerately did not raise in our brief is that prejudice should be either automatic or presumed when an IJ is found not to be a neutral arbiter. In the criminal context, for example, the lack of a neutral judge is considered structural error that automatically entitles the defendant to a new trial. So because we didn't make that argument, we would ask the court to reserve that question, regardless of whether it finds that the petitioner did suffer prejudice in this case. If the court has no further questions at this time, I'll reserve for rebuttal.
All right. Thank you, counsel. Ms. Volker.
Good morning, Your Honors, and may it please the court, Kathleen Volker for the Attorney General. I'm going to address the question about matter of YSLC first. We contend that matter of YSLC is not implicated in this matter. And there's no evidence in the record that the board failed to consider it or ignored case law. It just didn't cite to it because it's not implicated in this matter. And I want to point you to the record to show you what the petitioner actually presented to the board. So if you look at page, I think 47 of the record, petitioner, and I will.
I'm sorry.
47. What? Can you hear me, Your Honor?
I still didn't hear what the number was.
Oh, 47.
Thank you.
You're welcome. So I'm going to start at the bottom, last paragraph. While the immigration judge may have acted in a largely professional manner during the individual hearing, comma, her actions following the hearing create an appearance that she could not impartially adjudicate respondent's case. So then the petitioner goes on to talk about her consulting those police reports. And it appears he's making an argument that she's become biased because of extrajudicial evidence. So he cites the matter of YSLC, but I don't think that was the most appropriate case for the argument he was making before the board. And I think the board actually does a really good job of pointing the reader to matter of exam and matter of G for the proposition when someone's claiming that an IJ may have become biased because of some extrajudicial source or evidence. Now, I'm not sure if these police reports are completely extrajudicial, but I think the point of the matter is that it's when something outside of the main proceedings may affect the immigration judge. And I think it would have to be develop a personal bias. So then he goes on to talk about the attorney advisor and how the memo that accidentally got included in the decision that was sent to the petitioner. But I'm going to bring you right back to 47. And that first clause, when he's saying, while the immigration judge may have acted in a largely professional manner during the immigration hearing, he drops down to a footnote where he points out and basically says that the IJ acted inappropriately in that little interaction about the Spanish language and whether petitioner had full control of the Spanish language in her comments. He doesn't cite to any case law there. He doesn't cite to matter of YSLC. He doesn't make an argument about her belittling or being hostile. He doesn't go there. He doesn't cite to any case law in that footnote. He says he believes the outburst alone is enough to remand. And if the board doesn't agree, at least reprimand the judge for those comments. So now I'm going to bring you to page 5 of the record, and that is the board's decision. And it's the last paragraph with the due process arguments where they're addressing the due process arguments. And it's probably 2/3 down at furthermore. Furthermore, although we do not condone the IJ's offhand remarks in the one instant noted by the respondent, who is the petitioner now, the record as a whole indicates she behaved in a professional and impartial manner throughout the course of the proceedings. The board then cites the transcript, cites the respondent's brief footnote. Then it goes on to say, therefore, we conclude that the respondent was afforded a fair hearing. There is no indication that the immigration judge actions amounted to a violation of due process. Then they cite to matter of G and matter of exam. So I really don't believe that matter of YSLC was implicated in this matter. And now before the court, they're making more of a issue about the immigration judge comments, and they're using YSLC for the proposition that she didn't act in accordance with how immigration judges should by looking at the police reports. I'm not going to defend the immigration judge.
I think that's all a fair argument, but you also could read the footnote as separate and apart, because it isn't a footnote. I mean, okay. We judges and lawyers use footnotes all the time. And that the board is responding to that, but never does respond to the argument in text, which says, for this reason alone, the immigration judge did not meet the high standards expected of immigration judges, quoting YSLC.
Okay, so what I would have, the way we would look at it would be for this reason alone, meaning that she sought out those after the hearing, went out and looked at the police reports. I would have that I attribute it to that site. But if you disagree, then Your Honor, that's your prerogative. But my main point was saying that he didn't make this big argument about the IJ being hostile and it needing and violating the decorum of immigration judges. And there's really no indication that the board didn't consider that and find that this case wasn't implicated, that matter of G and matter of exam were more appropriate, because really before the board, his main argument was that the IJ went and looked at these police reports from the prior immigration judge hearing that were in the background evidence of a different proceeding. So when the board was looking at it, it wasn't asked to find that the IJ belittled anyone. And to be honest, when the board almost echoes the petitioner's comment that, I'm sorry. Okay. The board almost echoes exactly what the petitioner says, that the IJ acted largely in a professional manner or during the individual hearing. The board's not going to find more. The board's not going to, the petitioner kind of conceded that in our view. And had he argued more that he found that the IJ was hostile, belittled, and maybe then it would be more of a case for a matter of YSLC. And I tried to do, I didn't see any case, I don't think this court has cited to matter of YSLC. And that's why we had to go out of circuit to look at the Serrano-Alberto case from the Third Circuit. That case really does a really good job of grappling with YSLC, and it goes through and analyzes 3 cases in the Third Circuit, 2, Wang and Chan, which are when they find complete IJ bias. And actually, when you read them, it's quite jaw-dropping to see the conduct. And then they compare that to another case, and it starts with an A, I forgot the name of it, I know I have it here. It's Abdul Rahman. It's right in the Serrano-Alberto case. In that case, the IJ is just more impolite, but is not found to be biased or hostile. So we were kind of looking at the Serrano-Alberto case to try to distinguish how, even if you were to say that YSLC should have been considered, it wasn't implicated because it didn't, we don't feel that the IJ we don't condone her remarks, but it didn't have the ring of hostile and chilling as the other cases. And in fact, I just want to comment, when you read the YSLC case, they actually point to the Cham Third Circuit case that is in Serrano-Alberto. And they cite to it because it is a due process violation. Because when you find that an IJ conducts themselves in a manner that has a chilling effect on testimony, you can't have a full and fair hearing. So they cite to Cham on, it's page 3 of my printout, but I'm trying to find the pinpoint. It's 690, and they cite to Cham, and for the premise that when an IJ, that an alien is entitled as a matter of due process to a full and fair hearing, and when it's found that an IJ acts in a manner that's hostile or could intimidate the alien, the individual, they can't have a full and fair hearing because it has a chilling effect on the testimony. So YSLC actually cites to the due process cases from the Third Circuit. And as Judge Motz pointed out, anytime the cases, any circuits that have cited to YSLC, they've cited for due process reasons. Or they've cited for, there's another premise for YSLC, is when an immigration judge improperly invokes the federal rules of evidence. So
did the board in YSLC ever definitively state that the immigration judge conducted a due process clause violation?
In YSLC?
That his conduct violated the due process clause. Did the board ever state that definitively, that immigration judge's conduct violated the due process clause?
So on page 6, I think it's 690, when they address it, They don't condone the IJ's treatment. They've stressed that IJ proceedings should expect dignity, respect, courtesy, and fairness in a hearing before the immigration judge. They cite a Cham out of the Third Circuit stating that such terms are not merely advisory or aspirational, and an alien is entitled as a matter of due process to a full and fair hearing. Then they go on to say conduct by an immigration judge that can be perceived as bullying or hostile can have a chilling effect on an individual's testimony and thereby limit his or her ability to fully develop the facts of their claim. And then they cite to Wang, which is the other due process case out of the Third Circuit. Your Honors, when I was looking at case law for this, the Third Circuit seems to be, has a lot of immigration judge, I would say, would this be considered a bias or hostile?
I understand the Third Circuit's position on it, and well and clear, but the question is, when we look at the case of YSLC, is there a definitive statement that the immigration judge's conduct violated due process? And if it didn't, then it would seem to indicate that holding is distinct from and independent of the due process clause.
And one of the things, building on my colleague's question, that indicates to me that YSLC is not a due process decision, although I think it's close, I think there's stuff in both ways, is that there's no prejudice analysis conducted. And that, of course, would be part of the analysis if this was a due process violation.
Correct, Your Honor. But do you get to prejudice if you find the first prong is violated? Do you not have to get to prejudice if you find there is no full and fair hearing?
I thought we were talking about the question of whether USLC was a due process case or not.
So
remember, I think that the government says it is, and the appellant says it is not. It seems to me that although it's close, it probably is not, because there is no prejudice analysis.
Well, Your Honor,
which there'd have to be for a due process violation.
And read that in conjunction with what was actually held. It said, we conclude this hearing was not conducted in a manner that meets the high standards expected of immigration judges.
Right.
And then it goes on to vacate the judge's decision or remand for no hearing. There's nothing in there that talks about due process explicitly, much less prejudice, that would be necessary to get it out.
Your Honor, I guess I'm just confused because I would assume that if you found that the IJ tainted the proceedings, you didn't get a full and fair hearing. And I would have assumed that also them citing to the due process cases, but
well, that would kind of reduce what is necessary to get there with it if all you have to do is say the judge just didn't meet the high standards expected of an immigration judge.
That does sound like a supervisory role, like something
that would be pretty broad.
Might say about us.
Yeah. Well, never, Your Honor. Well, Your Honor, I mean, all we could go by is our view of the board's decision, which, I mean, you've found us wrong in the past, but that was our view. And we can also only go by how we've seen other circuits interpret it. And so that would be why we would lean towards that probably. Additionally, I wanted to just comment, I know that the petitioner pointed out when the board found that the immigration judge was improper without analyzing it and just said, we're not going to consider the police reports. And then went and did a de novo review. As you all know, that the board can only look at the matter of discretion de novo. But in order to evaluate any challenges to factual findings, they can only look at, the clear error review. And so that's what the board did there. And when I was trying to figure out how to maybe find an analogy, it's very much like a IJ reversal in a way. So like, for instance, I came across the Data Love case, and I believe Chief Judge Gregory was on that panel. And the IJ found cancellation, and then DHS appealed it. the board sustained DHS's appeal, did a de novo review, but they had to rely on the factual findings of the IJ. And I can't remember if they found any of the factual findings had clear error or not. But in the end, they ended up reversing the IJ and finding and denying cancellation as a matter of discretion. So I guess my point would be, when you're talking about clear error on that one instance about the relapse issue, if the petitioner argued to the board that he challenged that factual finding, the board can't look at that and evaluate it under de novo. It has to look at it as clear error. And because it found no clear error in that determination, that doesn't spoil the de novo review, I would argue. And Your Honors, if you have any more questions, I'd be happy to try to answer them.
All right.
Otherwise, we would ask that you affirm the board and deny the petition. Thank you.
Thank you, Ms. Volker. Mr.
Thank you.
Honorgrad, you have some time reserved.
Thank you, Your Honor. I recognize, of course, that exhaustion arguments are jurisdictional. I would note, though, that the government made no exhaustion arguments in its brief. So we would preserve the argument that any exhaustion argument was waived. And I would also note there is a circuit split over whether the exhaustion argument is in fact jurisdictional. More importantly, the board itself reached the issue and said the outburst was not sufficient to require a new hearing. And every circuit has held that when the board addresses an issue sua sponte, it's considered exhausted. And just finally on exhaustion, I would point the court to the Ramirez decision from 2018, which said that the exhaustion requirement only prohibits the consideration of bases for relief that were not raised below and of general issues that were not raised below, but not of specific subsidiary legal arguments or arguments by extension that were not raised below. With regards to matter of YSLC, Judge Mons, I can provide a citation for the source of the board's supervisory power, and that would be 8 CFR 1003.1 D12. And that's a regulation that this court has considered on many occasions, and it authorizes the board to take any action that is appropriate and necessary for the disposition of a case. And we think that would plainly encompass the authority to remand a case to a different immigration judge.
Okay, so what I am looking for, and I'm really hopeful you can show me where it is where you said in your papers to the board that the language that you complain about violating YSLC, where you even raised that?
Well, in the footnote that was being discussed, we certainly raised it. We quoted from the colloquy, and we said that this outburst is sufficient on its own to warrant remand to a new immigration judge.
Well, it's not exactly worded that way. We have this discussion of it in the footnote, to be sure. And then we have, to begin with, we have the discussion in the text. And the text seems to say, for this reason alone, not referring to the footnote. The footnote is the page before footnoting something else. So I'm just, since this seems to be the heart of your argument in front of us, I'm just a little lost here.
Sure. Well, we think there are two independent grounds for a remand under YSLC. The outburst during the hearing, which we addressed in footnote 4 on page 47 of the record, and the consideration of
21 of your papers. So it doesn't get a lot of attention, but go ahead.
And then the other one was at the top of page 48 of the record, page 22 of our brief, in which we also say, for this reason alone, the immigration judge did not meet the high standards expected of immigration judges. That's, of course, referring back to the consideration of the police report. But again, because the board addressed this issue, addressed the issue anyway, we think that the board was plainly on notice of our argument. I can see the argument could have been raised better below, but the board was on notice and it addressed the argument. And especially given this court's decision to Ramirez, we think that's sufficient for exhaustion. And to the extent, Your Honor, you think it's close or unclear whether a matter of YSLC requires a due process violation, we think the correct remedy would be to remand for the board to clarify that exact question. The only other point I was going to make was that the police reports themselves, the other side suggested that they may not be an extrajudicial source. We think they clearly would be, because they were not introduced during the hearing, even though they were introduced during my client's prior removal proceedings. They were not introduced during the current round of removal proceedings.
So is there such a thing as the record? Like here we have the record before the, in the immigration. In other words, were they in the record?
They were in the record of the prior case, but not this case.
So was the record both of those?
No, they're separate and apart, and that's why it doesn't appear in the administrative record before the court. Just as when a defendant is charged with goes to one criminal trial and then years later goes to another criminal trial, the record from the first criminal trial is not part of the record from the second criminal trial.
IJ find this?
Presumably, she summoned the record from storage, wherever it was, and looked through it. I can't imagine any other way she would have found it. I mean, that's why it's not in the administrative record, and it wasn't what we received as part of our FOIA request for this record. Okay. If there are no, yes.
You spent a lot of energy saying you actually did bring up this YSLC as precedent, and yet even if you didn't, and we conclude to some extent the YSLC did not implicate due process, the separate due process claim can be considered even if you didn't do it. And if that falls in line, the question then would be of whether the question of the partiality of the judge and the prejudice from it was adequately raised. Is that fair, what I'm saying there?
If I understand your question, yes, but I believe we certainly adequately raised it. I mean, it was not our primary argument conceitedly, but it was our separate argument. That the immigrant
walk in this world I just created for you. That is that you spend a lot of time, because it's real difficult for me, at least. Maybe Judge Mott seems to be having the same problem as to the extent it was actually raised independently on the YSLC, particularly as the precedent. But if we went further and delved into the question of what was the holding in YSLC, did it actually implicate the due process clause violation? And there's this broader statement about it, the judge there not meeting the standards. That then opens the door perhaps for an independent consideration of due process, irrespective of YSLC. Doesn't that get you kind of in the discussion? But it's been around. I'm trying to understand. Maybe help me out. It sounds like your position is if we don't believe you raised that independent claim on YSLC as precedent, then you seem to feel like there's no avenue. But I'm trying to see if you follow the perspective that YSLC does not deal with due process, then it's there.
I would say if the court finds that we did not exhaust the claim involving YSLC, I think we certainly exhausted the claim involving due process, and even the government does not suggest otherwise. So we would ask the court to rule in our favor on the due process claim. Thank you, Your Honors.
Thank you. Thank you both. Thank you very much for your arguments. We can't come down and greet you. No, you're virtual. We can't do it either way, but please know that we appreciate your arguments here, and thank you so much, and wish you well and be safe. Thank you. All right. Ms. Duncan? Mr. Duncan?
Yes, thank you. Good morning, Your Honors. May it please the court, Dana Duncan on behalf of Lawrence Y. Bush. Before this court is a single issue. Did the Appeals Council err by not finding the report of Dr. Gita Honda new material and relevant to the period before the hearing? While this alone would be normally the issue, strangely, it's tied to a separate issue, and that is the ruling by the district court made sua sponte that the 5-day rule precluded this report. At the district court, the magistrate found Ms. Honda or Dr. Honda's report violated the 5-day rule, an administrative regulation change adopted to avoid having late medical evidence submitted right before the hearing, reducing the effectiveness of an ALJ's ability to review and be able to process it in time for a complete hearing. The courts, and not just in this court, but I will note that there are multiple decisions that have been issued by the district courts in this circuit applying the 5-day rule. While ultimately this court should address the district court's misapplication of the law and then move on to the actual application of whether Dr. Handa's report should be deemed new material and relevant, and then applying the Myers factor, whether there is error meriting this matter or the report being submitted to the Appeals Council for review and consideration under the sentence 6 standard. Harmless error.
You say the Handa questionnaire was excluded or rejected by the Appeals Council, but didn't that council consider the report and found that it didn't change anything?
It did, but the problem is then you have the issue with the Myers standard. It doesn't really say what the information is. That's the problem, is there's no specific findings as to why. Applying Myers versus Astru, the court is to review the record as a whole. And in the Myers decision, it says if there's unconverted or uncontroverted evidence in the record, then the matter is reversed and the matter sent back for evaluation of that evidence when the Appeals Council does not provide articulation. And that's what we have in this particular case.
So how do the 2012 and the 2015 sleep studies support this Handa questionnaire?
It does, and she outlines exactly what it is. And she actually is a specialist in sleep. So this is a treating source statement, which should carry even greater weight, especially renewed by this court's finding or decision in Aracas, which outlines specifically, and this just carries under the treating physician rule by 1 week. And so therefore, it does apply in this particular case.
Did they test or examine the effectiveness of the claimant's medication?
That I'm not sure about, Your Honor. I think there was some consideration of that. Ultimately, though, the problem was that the medication that was found, or some of the medications had such significant side effects, he was very limited on what kinds of medication he could take. So even with the medications, he was still, as he testified, falling asleep 1 to 4 times a day at random intervals.
Well, and just on the last point on that questionnaire, you do say that you complain that they didn't give, the Appeals Council didn't give an adequate explanation. But we pretty much have said in our cases, they don't have to, haven't we?
Correct. But then that's when the Myers standard applies. And the Myers standard says that what you would then do is you have to review the record as a whole to see whether or not there's sufficient evidence in the record itself to sustain the Appeals Council's findings. And in this case, what we have here weighing against that is that we have an uncontroverted medical opinion of a treating source that supports a nurse, or excuse me, a physician's assistant or nurse practitioners whose report was in there, and which goes on to specifically counter some of the findings that were made by the administrative law judge in the decision. So the overall situation is this weighs very heavily for this being the unrebutted or uncontroverted evidence that the Myers court found sufficient to at least merit this matter going back for consideration to the Appeals Council. This
You
court,
know, the biggest problem I see here, it seems to me, is that, all of, you have the sleep studies in it that's here, but they don't seem to support that it's untreatable, this narcolepsy, with appropriate medication. And neither of those studies really assess the effect of those medications. They were sleep studies. They weren't medication efficacy studies. They weren't, you see where I'm going with that? In other words, you can conduct a sleep study. Yeah, he's got a sleep problem, but the question is, do these medications help? And there's nothing there that assesses that to show a change.
Okay, I understand your point, Your Honor, but I really can't address it because I don't have, I'm left with the record that I was given, and there really isn't a whole lot, and there was no questions done.
See, the problem is that then that questionnaire becomes inconsistent with what we know to be other substantial evidence in the record. And so, even your client said he was able to control his own symptoms with certain medications and dosages, and he even named one of them. And then, so that's the problem. Is yeah, you have a study and it's uncontroverted, but it does not go to the issue that's here.
Well, I think that the argument I would make, Your Honor, is in just general, the fact of Dr. Honda's report, who had been treating him for this condition, indicated that he was continuing to have these problems and noted them in her report, more than implies that it wasn't being, or the treatment provided was not being, or was not very effective. Otherwise, there wouldn't be this report 3 months after the fact indicating that he was continuing to have issues and that these periods of falling asleep were continuing.
So I just want to make sure I understand. It seems to me, if you have a doctor that says that, well, this situation is controlled when he's taking his medication in full compliance with his medical regimen, and you produce a study on sleep, but it doesn't address that, there seems to be a disconnect as to, how does that change anything? Until you actually get to that.
Well, as I indicated again, the report itself addresses that particular aspect and says that the problems continued even though he was being treated and medicated.
Well, that's probably where I want to make sure we're clear on it. It seems to me Dr. Handa herself seemed to suggest that the reason he wasn't getting these results from his drugs was because he was in non-compliance. And, that in and of itself seems to indicate there is some importance here beyond just diagnosing the problem if it is treatable. The question is, does this problem exist in a treatable fashion, and is he complying with the treatment there? That's what seems to be missing to me to make the connect here.
And while that might be the case, we don't know that's what the appeals council ultimately found is the reason for excluding Dr. Handa's report. What we have is no information whatsoever as to the basis of why they excluded the report. And I can understand the court's concern, but again, this is a situation where we don't have any idea specifically what the findings are. The ALJ didn't really address a lot of this. He basically gave less weight to this other medical opinion because of it. And as a result, we're kind of stuck in this kind of period of kind of a nether region that we don't understand exactly what's going on.
You and I thought we sort of agreed that at least case law said the appeals council doesn't have to explain why.
Correct.
So then we go to the ALJ and has already considered these sleep studies that were relied upon by Dr. Handa.
Correct.
And
the problem, though,
it says it supports a narcolepsy diagnosis, but what it doesn't do is to indicate that what the effect of having a prescribed medication compliance has on That seems to me to be the problem with at least where we are.
Well, the first question, Your Honor, is with Mr. Wybush taking the appropriate level of stimulant medication, is it nevertheless most probable that he would have fallen asleep at unpredictable times during the work portion of each day? And the answer was yes. So right there, Your Honor, that issue is resolved as far as this goes from Dr. Honda's report at record page 7. So, you know, I think that's sufficient from a treating source to trigger all aspects of this case, and specifically all of that. Now, I am unfortunately not, I think I have now lost or have no more time available, but
Yeah, you're correct.
I had a lot of more info stuff I wanted to address, but all right, thank you.
All right, we have time reserved.
All right.
Ms. Petty?
Good morning, Your Honors, and may it please the court. Shannon Petty for the Commissioner of Social Security. This case presents a straightforward and narrow issue. Does Dr. Honda's November 2017 questionnaire, which contains only a 20-word response, does not cite to anything about the efficacy of medication, and proposed Mr. Wybush was so impaired since 2012, 4 years before Dr. Honda began treating him, and a period where he worked the day shift 12-hour days full time and did so without problem per his own testimony, now deprive the ALJ's decision of substantial evidence? The answer is no. The mere fact that this document was signed by a treating source does not undermine the ALJ's decision here, given the weak content therein. Now, I'd like to first briefly define how to look at this case, because there were arguments focusing on the new Appeals Council evidence regulations and the 5-day rule. The agency here considered every document submitted. The 5-day rule arguments are not relevant because the 5-day rule was not applied here. No agency adjudicator declined to consider this document because it was not submitted until after the ALJ's decision. And the changes to the Appeals Council evidence regulations have not changed this court's standard of review. This court can and should continue to apply the substantial evidence and fact-specific inquiry it did in cases like Meyer when evaluating cases where evidence is first presented to the Appeals Council. Now, to just very briefly clarify, the quote 5-day rule actually refers to 20 CFR 404-935 in the regulations. And that regulation now requires claimants to either inform the ALJ about or otherwise submit all evidence no later than 5 business days before the hearing, unless an exception applies. There's a corresponding requirement at the Appeals Council level I'll speak about in just a moment. But the key point here is that that version of the regulation was not in effect until several months after Mr. Wybush's March 2017 hearing. The ALJ here considered every document submitted. She left the record open for 5 months and accepted all of Mr. Wybush's post-hearing submissions. She even sent him for 2 additional consultative examinations at his request, even though the record already contained a consultative examination. So the ALJ here considered everything that was presented to her. Now, Dr. Honda's questionnaire was presented to the Appeals Council, and the Appeals Council considered it. There is a corresponding requirement at the Appeals Council regulation that now explains that the council will grant review if, among other factors, a claimant shows good cause for not informing the ALJ about or submitting the evidence in accordance with 404-935. But again, 404-935, that version was not in effect at the time of Mr. Wybush's hearing, and the Appeals Council considered this document despite the timing of the submission after the ALJ's decision. The 5-day rule was not applied here. Rather, the council looked at it and found it did not create a reasonable probability of changing the ALJ's decision, a point the district court also affirmed. And even the magistrate judge here assumed that there was no issue with when this questionnaire was submitted in relation to the ALJ's hearing and decision in the first full paragraph on page 48 of the joint appendix. So the 5-day rule was not implicated in this case. The problem was not the timing of the submission, but the content of it. And the content here is what was lacking. It contains just 20 words of response, suggests Mr. Wybush was so impaired since 2012 when he was in fact working full-time 12-hour days during the day shift and testified he did so without problem. And it's devoid of meaningful support because it does not cite to either Dr. Honda's own treatment notes or any evidence addressing the effectiveness of treatment, which is what the ALJ relied on here. Now, in Meyer, this court explained that the standard where evidence is first tendered only to the Appeals Council is for the court to review the full record, including the additional submission to test the ALJ's decision for substantial evidence. And applying that test to the facts of this case, the ALJ here found that Mr. Wybush could work despite his narcolepsy because treatment was effective when used. This was on page 11 of the joint appendix. And Dr. Honda's questionnaire does not undermine this. Turning to the questionnaire at page 23 of the joint appendix, it contains just 4 questions and only a 20-word response. In question 1, Dr. Honda responded yes to a pre-drafted question asking if Mr. Wybush could fall asleep at unpredictable times during the workday despite appropriate medication. But this conclusion and the support cited for it are contradicted by the record. Walking through the remaining questions that purport to provide rationale here, in question 2, Dr. Honda cites a hypersomnolence diagnosis. This was already before the ALJ. The ALJ found hypersomnolence to be a severe impairment and considered it in the work capacity assessment. And as the Fourth Circuit has explained in Gross versus Heckler, a diagnosis alone is not enough. There must be a showing of related functional loss. Now, in question 3, this is the only other evidence Dr. Honda cites in support of her conclusion. She cites 2 sleep studies, one from 2012 and one from 2015. Both of these predate when Dr. Honda began treating Mr. Wybush in February of 2016. So she's not even pointing to anything from her own treatment records for support. And as acknowledged, these studies, they were also before the ALJ, they support the diagnosis of narcolepsy, but do not address the effectiveness of treatment for the condition. Which
that's the difference, isn't it, Ms. Petty? That's the difference, isn't it? Dr. Honda gives some medical explanation of the consequences, the effective. She says it cannot be treated with medication, that he will fall asleep at this random time. You're right, the studies were there, but the studies, as you said, gave the diagnosis. That and you agree with the diagnosis. That's not disputed. The question is, what is the prognosis? You see, there's diagnosis, then there's the treatment. Okay, you try the treatment. But what Dr. Hannah is saying, that the prognosis is going to exist notwithstanding medication because it is so severe that he will fall asleep at these random times. That was not before that. That's the treating physician. Now, you may disagree with that, but that's important. The studies, I would agree with you. This would make, well, the studies don't even show he has it. That may be something else. And it doesn't matter that it happened before she treated him. Physicians look at clinical studies all the time, sometimes years before, and that becomes the pathway to diagnosis, treatment, and prognosis. But the prognosis of us is important because that tells you, and she says clearly, even if medicated, not if he's compliant, but even if medicated, assuming such, he still will have the prognosis of sleeping at random times, and it can't be controlled. That's what she says. You can't whisk that away.
Your Honor, you're correct. She does respond to that question in the affirmative. However, the support, 2 points to respond to that. One, the support that she cites within this questionnaire does not support her own conclusion. Again, those 2 evidence are the only objective findings that she cites. They're the only records she cites, in fact, and none of those records speak to the effectiveness of treatment, which is what the ALJ relied on here. Not only that, but the record contradicts Dr. Honda's conclusion. Let's walk through it briefly. The record shows that Mr. Wybush was diagnosed with narcolepsy in late 2012, prior to the relevant period. However, his medication was effective when he worked the day shift. Mr. Wybush worked the day shift for more than a year. He worked 12-hour days full time, and he testified, quote, he wasn't having any problems on the day shift, end quote. This is on page 43 of the transcript and page 427. Now, during that time, he reported that Provigil and Mirapex were, quote, quite effective for him in March of 2013. Now, he was later transferred back to the night shift, fell asleep at work, and was terminated. However, falling asleep during the night shift does not automatically preclude daytime work. And Mr. Wybush confirmed that Provigil continued to work well for him after this time. For example, in November of 2013, so nearly 4 months after he stopped working, he confirms that Provigil, quote, is working well. However, he'd been out of the medication for about a month. This is on pages 466, 469, 492, and 543 of the record. Now, this was during an initial consultative with the Veterans Administration, and the VA prescribed a different first-line medication for this condition. They prescribed Ritalin. And so the treating neurologist at that time started Mr. Wybush on a 30-day trial of Ritalin. It looks like Mr. Wybush was without medication for most of 2014 as he received that 30-day trial in November 2013 and nothing thereafter. However, in late October of 2014, he began Provigil. The same medication he confirmed to the VA was, quote, working well 4 months after he had stopped his job. And the record shows that it continued to work well for him until he reported in June of 2015 that it had been less effective, quote, for a month or so. And this is on page 905 of the transcript. Importantly, providers at that time linked that complaint to Mr. Wybush's other medications, 3 of which caused sedating side effects. And Mr. Wybush was taking each of those sedating medications 3 to 4 times a day. So his treating neurologist recommended adjustments to those medications, including discontinuing use of them during waking hours. However, Mr. Wybush testified on page, and that recommendation, by the way, is on page 903 of the transcript. Mr. Wybush testified, however, that he continued to take some of those medications during the day at his administrative hearing. Now, psychologist Dr. Honda began treatment in February of 2016. Her plan was to switch to Adderall, and if Adderall did not work, she planned to switch to Nuvigil, which was another medication Mr. Wybush previously confirmed worked well for him in the past. Dr. Honda documented some ongoing issues with compliance in 2016, and she did adjust Mr. Wybush's Adderall in November of 2016. However, she never made the switch to Nuvigil, suggesting that Adderall was adequately controlling his symptoms. So she didn't follow through on her treatment plan if Adderall was in fact not working. And her final treatment note of record confirms this point. In February of 2017, so just 1 month before the hearing in this case, Dr. Honda indicated that medication caused fidgeting and restlessness for 2 to 3 hours after the final dose, and insomnia if he took the medication later, the inability to fall asleep. It makes no mention that the medication was ineffective. And Dr. Honda also gave Mr. Wybush information on vocational rehabilitation at that appointment, which suggests she believes some work was possible. This is on page 1190 and 1193 of the transcript. And so the record here shows and supports the ALJ's conclusion that treatment for narcolepsy was effective when used. Dr. Honda's questionnaire does not undermine that. And in her final, in question 4, the final question in the questionnaire.
It does undermine it. The question is how much weight should be given to it. It certainly undermines. How would you suggest that? How could you say it doesn't undermine? It does undermine. The question is how much weight you give to it. Because what she's saying, she's a physician. You know, she's I mean, in terms of his treating person. And we give a lot of weight to that, right? How many, did he have an IME here?
Your Honor, before the
Did he have an IME?
In independent medical examination, yes, he had 3.
Okay.
There were 9 doctors.
Did they treat him? Any of them? Did they treat him? Anybody? They didn't treat him, right?
There were 9 doctors who considered Mr. Wybush's narcolepsy, 6 of whom offered opinions, including a treating nurse practitioner. And then the ALJ also sent Mr. Wybush for 2 additional consultative examinations after the hearing, and there was already a consultative examination in the record at that time. So there were 3 evaluations in the record here. And to speak to your point about the treating source, it is absolutely correct that Dr. Honda is a treating source. However, it's not merely the source that's relevant, it's the content, and the factual content therein is not adequately supported and is contradicted by the record. Again, Dr. Honda indicated Mr. Wybush was so impaired since 2012 when he was working 12-hour days full-time during the day shift, and testified on page 43 that he had no problems with that. While she cites to a sleep study, she does not cite to anything, including her own treatment notes, addressing the effectiveness of treatment. And Dr. Honda's final treatment note indicates, again, only fidgeting and restlessness for 2 to 3 hours after the final dose of medication, with insomnia if the medication was taken later, and inability.
All this very well. All this very well. And Ms. Petty, you're doing a great job. You know the record very well. But I'm a judge. You're a very adequate and very competent lawyer, but we're not physicians. We don't do that. In this case, this is a very important case. The man lost his job, and he said, well, he fell asleep at night. And then you say, well, it doesn't mean you can't work in the day. Well, apparently somebody thought it was enough that falling asleep at night was enough and didn't switch it. But why shouldn't this case be remanded so that this can be, you look at this? These are important matters in terms of, in that sense. And this is a treating doctor who says this emphatically, that medication is not going to solve his narcolepsy. It's not going to do it. We can't wish it away. And it is important. And that's the thing I think about the way we deal with mental issues in this country in general is just incredible. You have these cocktails of things where you treat this, but it has contraindications. So yes, maybe we keep having these cocktails of things. You're doing this, you're doing that. But what toll is it on a person's psychic and their ability, their quality of life and those things? Treating physicians said, listen, enough is enough. Medication is not going to solve this man falling asleep. And why should we not, in terms of fairness and due process, send this back? They didn't have this before. And you might be right that they look at it and examine her and those things and, well, on the balance, but it's bereft of something that's very important. Why is it not? And like I said, this is not discounting you. I think you've done a great job, but we're not experts. And his treating doctor says, this is an important matter. And why do you just ignore it? It should go back. You didn't have that when you heard this. You didn't give him an appeal. That was gone. I know we can't, that's not in our wheelhouse, but certainly sending this back for remand is. Go ahead.
Your Honor, I see that I'm out of time.
I'll give you the long comment so you can go ahead. At least I confess to mine. But there's a question at the end of it.
Absolutely. Your Honor, this court can absolutely consider this questionnaire, which again is not well supported and is contradicted by the factual record. Now, as an initial point, the Appeals Council did consider this document. They found, however, it did not create a reasonable probability of changing the outcome here, a point the district court concurred with on page 65 of the joint appendix. However, acknowledging that this is a treating source opinion, this is not a document that has to be weighed in the first instance before this court can conduct its substantial evidence review. In Meyer, this court did not hold that remand was required for the agency to weigh an opinion anytime it was not presented to the ALJ. Meyer was very careful to carve out a fact-specific holding, noting that the evidence in that case presented a problem, but that the court can affirm when substantial evidence, considering the record as a whole, including the additional submission, supports the ALJ's decision. And it was the particular record in Meyer, the content of the submission, and that ALJ's particular emphasis on the lack of a treating source opinion that was relevant. Indeed, the very first sentence of Meyer opens by acknowledging that Meyer suffered severe injuries in an accidental fall. Meyer had a 25-foot fall, multiple reconstructive surgeries, and I believe almost 200 physical therapy sessions. So we don't have that type of record here.
You know why? Because, right, that's my whole point. We can understand things that are physical. Someone falls down, they break a limb, but it's so difficult, it seems like, to understand the mind. And the mind controls all of that. It is the epicenter of life and quality of it. And so you're right. Nobody fell down. There's no broken bones. There's not that. It's just a psychologist saying that. No, it is very important. It is the essence of life. Oh, okay, I'll let you go. You counsel, you wanted to say something. I don't want to cut you off.
Oh, I'm so sorry. I have just one more point.
Sure, go ahead.
Thank you, Your Honor, for the opportunity to go a little bit beyond my time here. Absolutely, Your Honor. The commissioner is very mindful that the facts of each particular case are what are most relevant. There's no categorical rules here. It's simply the commissioner's position that Dr. Honda's questionnaire, which was considered, is not supported internally, and it's contradicted by the record, including multiple statements from Mr. Wybush that medication was effective, and Dr. Honda's most recent treatment notes showing, again, only fidgeting and restlessness for a couple of hours with no mention of the medication being ineffective. She never changed her treatment plan, which would have happened if the medication was not working. And she also referred Mr. Wybush to vocational rehabilitation, suggesting that she thought some work was possible. A final point we note is that the remedy in cases where there's additional evidence presented after the ALJ's decision is twofold. One, like here, a claimant can submit it to the Appeals Council for consideration and subsequent appeals. The claimant can also file a new application submitting that same evidence, and that was also done here. Your Honor, it's just our position that considering the weak content in Dr. Honda's questionnaire, it was considered, but it did not deprive the ALJ's decision of substantial evidence, given that it's contradicted by the record showing his own reports that medication was effective, Dr. Honda's own treatment notes, and her conclusion that he's been so impaired since 2012 when he worked full-time days during the day shift for 12 hours and testified he did so without problem. Thank you for your time this morning.
Speak, if you will, to the standard of review that we have here and how that might impact our decision.
Absolutely, Your Honor. The standard of review here is exactly that which was articulated in Meyer, where evidence is presented for the first time to the Appeals Council, and the council denies review and includes that evidence in the record. The court tests the ALJ's decision for substantial evidence, considering the entire record, including this additional submission. And applying that test here, it is the commissioner's position that based on the relatively weak content of Dr. Honda's questionnaire, it does not deprive the ALJ's decision of substantial evidence. It's further the commissioner's position that Meyer did not hold that the court needs to remand for the agency to weigh an opinion anytime an opinion is presented to the, presented after the ALJ's decision. That couldn't be the rule. And, very briefly, although not cited in our case, I would be happy to prepare a 28J letter. I found a case in the 10th Circuit, Vallejo versus Berryhill, that is also very instructive here. The Vallejo case had the same factors that are at play: a treating source opinion that was not presented to the ALJ, that purports to undermine the ALJ's decision, and that was the only treating physician opinion of record. However, the 10th Circuit there explained, and let me just very briefly quote, that they rejected the notion that the matter had to be remanded for the agency to weigh the case in the first instance, and instead remanded to the district court to determine, consistent with the test articulated in Meyer, quote, if substantial evidence in the administrative record, which now includes an additional opinion, supports the ALJ's decision. And it's our position that that's the standard to be applied here, Your Honor.
So it was remanded to the district court?
Yes, the posture of that was originally that the district court remanded to the agency to weigh the opinion in the first instance. That was appealed to the 10th Circuit. The 10th Circuit said, no, we don't have to remand to the agency to weigh in the first instance, because, citing the same logic applied by this court in Meyer, it's only when the Appeals Council gives a notice of determination or decision under the regulations that it has to articulate its finding of facts and its rationale. In that instance, the weight afforded to a treating source opinion. But when the appeals council simply denies review, which is what was done here, it, quote, was not required to follow the same rules for considering opinion evidence as the ALJ followed, end quote. That's Vallejo, V-A-L-L-E-J-O versus Berryhill 849 F3D at 951, and specifically at pages 955 through 956. And again, if the court would like a 28J letter on that, I'd be happy to provide it. So the standard here, though, is to test the ALJ's decision for substantial evidence, considering the entire record, including the additional submission from Dr. Honda. And it's the commissioner's position that even considering this opinion, the record as a whole still continues to support the ALJ's decision, and the court should affirm.
All right, thank you.
Thank you very much, Your Honors.
Ms. Duncan, you have some time.
Thank you. I would like to just briefly comment. First of all, the issue of the 5-day rule was only brought up because
Ms. Duncan, it seems like the 5-day rule, she's put it off the table. I mean, you can argue the case where you want, but you only have 5 minutes. It seems like she just told you that's fine. We're going to spend 5 minutes on that?
That's why.
You're going to stump something that's already dead?
Okay.
Well, go ahead.
All right, thank you. As far as the rest goes, there's one aspect of this. First of all, the claimant, Mr. Wybush, was on tramadol and other heavy doses of medication, which, according to the record, and I mean, I could provide those supplementally to show where all these other medications cause drowsiness when you already have narcolepsy and you have multiple other medications you're taking that cause sleepiness. I mean, it only makes sense that it's going to be very difficult at times to regulate, even when the medication for narcolepsy is effective. And there are points throughout the record that say that it's not. And I've cited some of those in my reply brief. One thing that's constantly lost in these cases is the fact of these Social Security law is, as I've often told associates, starting the duck-billed platypus of law, because it doesn't match anything else. And the cases of Sims and Carr addressing issue exhaustion, the Supreme Court's outlined all the things that are different. These are inquisitive or inquiring situations. A law review article, 29 George Mason Law Review by John C. Dobbin will be released next week. He uses Carr and Sims to outline that there's some things fundamentally wrong with how we consider these cases. And ALJ and under Sims of the Appeals Council acts as a judge, a representative of the government who can cross-examine and review or pick apart evidence, and is also an advisor and required to by regulation to fully develop the case to see that a fair hearing exists regardless of whether the claimant is represented by counsel or otherwise.
So you make, I think your points are well taken. What I'd like for you to direct your attention to, what looks to me, when I look at it, is this forgiving nature of the substantial evidence standard. The question being whether this ALJ's decision rested on substantial evidence. And what is it? Is more than a scintilla of evidence, but less than a preponderance. And when you're looking at conflicting evidence that reasonable minds could disagree because there's conflicting evidence in the record, I'm sympathetic to the cause that, you know, physicians' positions are given a lot of weight. But here, at least the record, and I could let you go on, but I want to make sure you address my concern. What the record seems to indicate, you got 2 sleep studies that come up, nothing about medication. And then you got the naked opinion, well, medication won't help. But there's record evidence all through it that medication has controlled this. You got a whole year he's worked with this medication. And also non-compliance is the problem that he's having here. And it is that standard of review, the substantial evidence standard of whether this rests upon evidence that supports the ALJ's decision, understanding the case law makes that clear, that is more than a scintilla of evidence, but less than a preponderance. So address it from our job here, not what we wish the evidence we could do or what we would do as ALJ, but address it from the perspective of what we have to do as an appellate court, constrained by that standard.
Thank you. Again, Dr. Honda's report indicates in a direct answer to the question. She was a sleep expert. She had been treating the claimant for a number of years. If the evidence alone was not sufficient to establish controlling weight, it was sufficient enough to establish consideration of the various factors. Considering that part of the reason why the nurse practitioner's report was rejected was a lack of support in the overall record, we now have a situation where we have a treating source, an expert on that subject, who says basically the same things and outlines in detail, or at least the nurse practitioner's report provides more detail than Dr. Honda's does, but at least that's enough. I understand that we're not asking for award of benefits or that the matter should be given, it's a matter of whether or not Dr. Honda's report is sufficient to raise questions as to the validity of the underlying case. It talks in there in detail about credibility and subjective statements.
Mr. Duncan?
Yeah.
I don't think what you've just stated is the question. As my colleague just told you, what we're doing here is deciding whether there is sufficient evidence to meet the substantial evidence test. So that's what we're deciding, not whether there's some doubt has been placed on this. Right?
Yes.
You disagree with that?
No, I do not disagree. It's not an issue of doubt. What it is it's an issue of how or whether this is sufficient to tip the scales enough that this should be reevaluated.
But there's no sufficient evidence to support it. If this is sufficient to do that.
I would argue it is, simply because of her nature as an expert and her long treatment history, and the fact that she did make a statement opining specifically that even with medications being appropriately provided, he would continue to have periods of time where he'd fall asleep. We're not talking about having to establish 4 or 5 times. I would assume by most employer standards, 1 time falling asleep at the job is likely to end in termination. 2 is definite. And that's where we are. It's hard to provide the type of evidence, it's not like we can hook up an MRI and show the medication is effective or the medication is not effective. What we have here is a situation where we have a medical expert who specifically says that it will continue to happen regardless of the medications and compliance with the medications.
But you can determine through a medical efficacy study as to whether an individual is taking medicine. First, you can ask the individual, is it taking it? Then I think you pretty much can take tests that indicate, is that medicine in his system? And that's the disjoint here. There's nothing here except 2 sleep studies and nothing that even maybe her questions, to him, that if you said, well, based upon the fact that he indicates he's taking his medication, there's nothing to indicate otherwise, I conclude it doesn't make a difference. All it is doesn't make a difference, medical studies. And then you get all the information in the record that indicates while he's taking the medication and complying, his condition is good. So again, it's not a question of what I would do as ALJ and may have gone the other way, may agree with it. But the question is that ALJ's decision supported by substantial evidence? And that's a pretty forgiving bar from what I see. We just kind of have to do our job.
I understand. And what I would go back to again is the framing of the question from Dr. Honda is, let's assume that he is taking all of his medication and everything is in compliance. Dr. Honda has indicated he is still likely to fall asleep. And that's what we have. The gist of how effective the medications are or are not is resolved by the fact that she said, even if they are effective, he's still going to have the problem.
That's evidence, but the question hasn't been resolved because there's evidence the other way.
I think the point you made, Mr. Duncan, you sort of glossed over this somewhere, but it's very important. It's not only just that Dr. Hannah would give treating healthcare providers evidence, but also they gave little to no weight to the nurse practitioner's opinion that he would fall asleep in an upright position. Said because he or she did not have the gravitas. Well, this also, by this opinion of Judge Hannah, that would be able to restore to some degree. So it's almost like substantial evidence is not numerosity. That's a difference. Okay, you may have several IMEs and those kind of things, 5 of them. That's numerosity. But when you have someone who's a treating physician, that's in terms of, so that was the case, it's substantial because we have 5 people that as an IME who never seen the person, for example. That's in there. It's numerosity. But weight, in other words, you would never win a case because I've never seen a case yet that in these cases where they didn't somehow on the other side say, well, I think they're fine. There's nothing wrong with them. People have to almost be half dead in some cases. Kidney problems and all kind of hypertension. Well, they're still breathing. So is that substantial? Treating physician, no, I've tried these things because you're giving people stimulus, and it's science. You say, okay, I can keep you awake maybe, but the stimulations that's required to do so are contraindicated to your health at some point. That's what treating physicians do. Oh yeah, I can keep you, like a zombie, the person is asleep, but what is that doing long term? But it's not, so I don't know if it's substantial. It's like, as long as we can say something would keep you awake, that's substantial. But the treating physician said, no, balancing what is required, and we get to a point, enough is enough. Whatever you do in terms of reasonable treatment, he would still fall asleep. That's important. And that's weighty, I think, at least for a remand to look at this in a sense. That's what it's arguing. And my dear colleagues are absolutely right. We are, if you will, constrained by it. But we're not constrained, though, by the nature of the cases involved. This case is a psychological case, too. People just think falling asleep. It's a mind, too. It's a lot of things. And you're giving, these are stimulants. I think, and are correct, Mr. Duncan, are these basically stimulants that you're giving a person?
Correct. Yeah, and you're correct, Your Honor. And I did note that in my brief that this really is supportive of the opinion of the nurse practitioner that was rejected by the ALJ. And many of the reasons provided for rejecting that report were contraindicated by Dr. Han's report or Honda's report. And so I would argue that those points are enough that it would question whether a reevaluation, and really this is basically a harmless error standard as far as I'm concerned, is whether or not this is likely to result in the standard for the appeals council. Is this likely to result in a different outcome? Well, now you have 2 medical opinions saying the same thing, one by a treating source applying the treating physician rule. It very well may, and that's all this court has to do is indicate that this is enough, that this may result in a different matter. It doesn't necessarily mean it has to, because it could very well go back and be handled and shown that it is insufficient. But the issue is not that as much as it needs to go back to have further evaluation.
All right. Thank you, Mr. Duncan, and thank you, Ms. Petty. You both did a great job, and all these cases are tough, and you ably handle all of them very well. Thank you so much. You're virtual, so we couldn't shake your hand anyway, but know very well much that we appreciate your arguments, and we wish you well and stay safe. Thank you so much.
Thank you, Your Honors. Have a nice day.
Thank you, and as well. And we'll ask the clerk to adjourn the court until this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.